Good evening. This is a continuation of a public hearing regarding ZBA FY 2013-11. Continuation from a hearing, public hearing that began December 20th. It's an appeal of the issuance of a building permit that was issued on November 5th to demolish an existing accessory structure, which is a barn, under Section 10.1 of the zoning bylaw at 290 Lincoln Avenue. And I wanted to, by way of housekeeping, try to summarize what I thought we covered during on December 20th, and then note for the record some of the new materials that we have. So when we met on December 20th, there were a number of issues raised on appeal, some of them regarding notice, and specifically whether or not the proper notice was given under Chapter 40A, Section 11, whether the proper list of abutters was used to provide notice, and also a question of whether the Historical Commission was required to open a new hearing because of alleged defective notice, and also an allegation that the Historical Commission failed to follow open meeting law. It was my recollection that on these issues, the board had determined that there was no merit. And if that's not clear on the record, then we'll have to do that at some point tonight. But that was my recollection of how those issues were resolved. Left unresolved were the substantive issues regarding the historical significance, if any, of the demolished structure, and I suppose the process by which the Historical Commission reached its decision. One of the remedies, and this is, I think I'll take a shot at explaining why I thought the remand was appropriate. And it was one of the remedies that was requested in the appeal was remand to the Historical Commission for reconsideration. And specifically in light of new evidence, both that bore on the substance of the appeal, but also in the process. There was a claim that some misleading statements were made on the application form on the demolition permit, specifically related to the reasons why the owner was seeking to demolish the barn. And it seemed to me that if we were going to review the Historical Commission decision based on new facts, that they should first have a chance, in all fairness, to review those facts and make their own decision. And that we would not be second-guessing them based on evidence that they had not had a chance to evaluate. So that remand did occur, and so we have new in the record minutes from the Historical Commission meeting regarding this matter on remand dated February 5th. There's an additional set of minutes dated February 19th. And then finally, there's the Historical Commission decision on remand. I guess I would just also add, with respect to the remand, that in my mind, I in no way meant to malign the Historical Commission or any of its members, their qualifications, that this was simply a matter of fairness and giving them a chance to review facts that they hadn't had before them the first time they reviewed the issue. Let's see. So I think I'll also note for the record, there's a letter submitted by Elisa Rubenstein dated March 28th, and there's a request by Mike Hankey, who's the chair of the Historical Commission, to speak this evening and I think summarize the Historical Commission's decision. So if there's no objection, I would like to invite Mr. Hankey to do that. Yes, sir.
I believe it would be useful for us to have some discussion about this standard of review that we'll be applying so that it's understood as the discussion goes forward, what standard it is that we'll be applying to make a decision.
Well, there's an opinion from town council which, and correct me if I'm wrong, suggests that we should grant deference to the decision of the Historical Commission. I've taken a different view that our our standard of review essentially is that we step into the shoes of the Historical Commission and that no deference is required. And I guess my understanding is informed also by my belief that it's the zoning board's job to interpret the zoning bylaw. And for better or worse, this demolition delay provision is part of the bylaw. But I'm happy to be persuaded otherwise.
Well, Mr. Chairman, I have given this some thought. It's not black and white in this instance, as we may have discussed before, because we have this unusual situation where the demolition delay bylaw has been made part of the zoning bylaw. So I agree with your last point that when the zoning board hears a typical administrative appeal, and that would be a decision of the building commissioner, clearly the zoning bylaw does calls for the zoning board to step into the shoes of the building commissioner and can make any decision that the building commissioner could have made. So one could look at an appeal of this nature in the same light, but the reason that I had opined and still believe that the deferential standard is appropriate is because here we have an appeal of a deliberative body. So when a building commissioner makes a decision, it's usually unlimited information. It's based on the information available at that point. But as the zoning board does, the historical commission in this instance held a public hearing, heard from people who spoke to both sides of the issue, or for that matter spoke neutrally but added additional information, and rendered a decision based on the deliberation of the commission. And certainly a court reviewing that decision, and in the normal course, when a demolition delay bylaw is a general bylaw, it goes to court, and the courts do apply the deferential standard. And there is ample case law, and they point directly to the Zoning Act and say this is the standard we're going to use, that the decision would be overturned only if it's clearly erroneous as a matter of law, or if there's an abuse of discretion, it's arbitrary and capricious. So, as I said, here we've got a hybrid. You could look at it either way, but I am persuaded that the deferential standard is the right standard.
And with that, as I understand, and this is the first such appeal that I've been involved with, and maybe the first in the town's history, if there were an appeal from a site planning review decision of the planning board under this procedure, would that same deferential standard apply? I'm just trying to understand the sort of larger view.
Well, there again, you have a bit of a hybrid, and that, of course, is also not anticipated, at least not by the Zoning Act. As you may know, it's not well known, but site plan review is not described, is not mentioned in the Zoning Act. It's something that was created quite a while ago. That's to say now probably 40 plus years ago. But it has been around in zoning bylaws for a longer period of time. And frankly, I've seen communities handle it both ways. So it's also not crystal clear.
Okay. Any questions of the other members of the panel?
Yes, I think it's worth just spending a little bit of time on this, and I want to be clear. In my thinking, and our thinking may be different, and so when we go forward in this hearing, people should understand that we may be applying different standards of review. But this reference to the deferential review, I'd like to read, Mr. Bard, the paragraph from your December 12th opinion to us, spelling out the recommended standard of review. And by the way, that doesn't use the word deferential in it. And, to say deferential sounds like, well, it's kind of a soft, I'll just accede to what someone else wants. But here's what it says. In my opinion, the board's review of the Historical Commission's decision should follow the basic rules governing appellate review of an administrative action. That's the point you've made, and there's some discussion whether it's necessarily the case, but then you've described what that is. Thus, if the Historical Commission has, in the discretionary exercise of its expertise, made a choice between two fairly conflicting views, and its selection reflects reasonable evidence, the board should not displace the Historical Commission's decision and substitute its own judgment for that of the commission. And you cite a case. That's the sense of deference here, that if there are two reasonably conflicting views, that the board should not displace the commission's decision. We should not displace. The Historical Commission's decision should not be disturbed unless the board finds it is based on legally untenable ground or is arbitrary and capricious. In this instance, the board will not have the usual broad discretion available in a typical appeal of the building commissioner's action. Now, in my view, it only makes sense under the standard that this describes, it makes sense that we would remand, because we're asking the Historical Commission to reconsider the facts, reapply the law, make a decision, and bring it to us so that we can review it. If we're not going to sort of give some, now I'll use the word deference, to the Historical Commission's decision, why would we even bother remanding? We didn't decide. We could have been a fact finder ourselves, I guess. In any event, I want to be clear. I am intending to apply the standard of review that Town Council has recommended to us. I, as a lawyer, believe that that's the correct standard to apply. I recognize that other people may feel differently, but that's my view.
Ms. Greenbaum?
Will you please tell me in English what he just said?
I said that I'm not going to listen to testimony and decide, well, what would I decide? You know, full stop. What do I personally think is necessarily the best thing to do? I would rather ask, what information did the Historical Commission have before it? How did it weigh it? How did it apply the criteria? How did it describe it in the decision? Is it arbitrary and capricious? If it's not, and if the right criteria are applied, and if facts have been found, reasonable facts, I'm going to, now I'll use the word deference, give deference to it.
I guess I agree now that I know what he said.
Well, yeah, so I think Ms. Greenbaum was stating her agreement with the position articulated by Mr. Airgood, and I'm persuaded that given that clarification, that the standard articulated by Town Council is the one that we can rely on. It seems we're in agreement on that issue. So is there any other preliminary issue that, okay. I actually do have one other preliminary issue then, and it relates to the nature of any remedy or relief. This is again a question for Town Council. And I guess the question is, if this board did find that the Historical Commission had acted arbitrarily, capriciously, or had abused its discretion, I'm not saying that it would, but if it did, what remedies would be available to this board? Are there those set forth in Article 13 or something else, something less?
Well, I think we need to look at Article 13 at the demolition delay bylaw, and the decision available to the Historical Commission before the barn, while the barn was standing, was either the decision that it made, which is not to impose a demolition delay, or to impose a demolition delay. And so logically, your choice would be, if you don't agree with them, obviously if you agree with them, then you agree that no demolition delay was required. If you disagree, you could impose the demolition delay. I mean, the barn has been torn down. I think we may have discussed briefly last time. Theoretically, could you require that the barn be rebuilt? I mean, I don't think we need to go there. I think that the barn having been demolished, the issue at this point would simply be a delay in any substitute project going forward. And so I think logically and from a common sense point of view, that would be the zoning board's recourse in reviewing the Historical Commission's decision. If you decided that you disagreed with them, then you would impose the demolition delay. The demolition having occurred, you'd impose the delay part of it.
Thank you. That makes sense to me. And part of this arises from the awkward posture of this case, in which the appeal really couldn't be made until the building permit had issued. And yet the subsequent appeal could have no sort of effect or stay. on the building permit under, as it normally would under Article 11. The building commissioner couldn't issue a building permit if there were pending appeal. There's sort of a chicken and egg problem here, and I do worry that the process, the appeal process sort of doesn't get full due process when it's possible for the harm to occur, sort of irrevocably occur before the appeal process has run its course. So I'm hoping to talk about that at some point tonight. I don't know if we're going to fix it tonight, but I want to at least address that issue. And
I also have a statement on that issue,
okay.
but I want to hear the hearing first.
Okay, so why don't we move forward then? I think first we'd like to hear from Mr. Hankey, who I believe was going to make a presentation regarding the Historical Commission's reasoning and decision.
Okay, Michael Hankey, the chair of the Amherst Historical Commission. This was an unusual case from the beginning because typically when we do hold a demolition delay hearing, we're the advocates for the structure. I mean, that's how it typically works. To my knowledge, I've been on the commission almost 8 years. There's only been one other such hearing where the members of the public actually showed up and they were supporting demolition. In this particular case, when the appeal was filed and you heard the appeal, I was deathly ill and could not make it here for that. I did watch it on video, and I learned that you can say whatever you want to this board, whether it's true or not, and you have no way of knowing that. And when I watched that video, I was really disappointed in some of the members of the public who were basically telling you non-truths. They just were, I don't know if there were so much lies as they were just misinformation. There was comments about rushing through the original hearing. That is not true. Everybody got to speak. When they were finished, that's when we closed the public hearing. The only person we did not allow to speak was somebody who was reading a manifesto about the applicant. And that has no place in a commission meeting. You can't defame somebody. Has no relevance to a barn demolition. There was somebody who reported that we were rushing through to accommodate a birthday party. Yes, there was somebody at a birthday, but as chair, I didn't even know that. And that person wasn't supposed to be there that night. We had a quorum without them. I found out later that they had a birthday party. So some members of the public accused us of rushing for the birthday party, and that's just not true either. We treated this hearing like we do all demolition delay hearings. The other thing I'd like to say before I talk about the remand is that the commission, this current commission, has an incredible group of individuals. One person's a professional historic preservation planner. Another has a PhD in architectural history. I've spent 30 years in interpretive exhibition design. I'm a designer. One area that I'm really interested in personally is this period of house and barn. I have a collection of books about it specifically. So we do not take this lightly. The person whose birthday it was is a rabid preservationist and instigated or started the program with the commission to survey our existing outbuildings in Amherst, just to get a record because they are disappearing so quickly. Now, in terms of the remand, when we were discussing the remand in our next meeting, we weren't sure exactly what to do. Staff told us that we didn't have to hold another hearing, that we could review the case and write out our comments about each specific point in the bylaw. But one thing stuck with us, and that was the fact that one of the abutters was not notified. And after some discussion, we decided that we just wanted to rehear the whole case, hear everything new, just start over, wipe the whole thing out, and start over again, to be fair to everybody. And that's exactly what we did. We held another hearing. We listened to additional testimony. There was no new substantive evidence about Warren Brown that was presented. I mean, there was very little. There was some, but there wasn't very much. And when we went through the various criteria, there was less support the second time around for some of these criteria than there was the first time. And the decision hinged on a couple of main points. One, this is not the house of Warren Brown, it is a barn, it's an ancillary structure. And the second was, how important was Warren Brown to the town? And that was something that was very difficult to determine, because he wrote quite a bit in publications. This was at a time when there was no email and there wasn't an internet, and people communicated by writing. But he was also a real estate agent, a real estate developer, ironically, and an insurance salesman. So we tried to draw parallels to somebody living today in Amherst, and we really couldn't do that because we don't know of anyone who's doing those types of things who's also present in the community as a writer. So it was very difficult to determine just how important Warren Brown was at that time in Amherst. He had affiliations with some important people, but those affiliations really had nothing to do with the barn. So we're talking about the barn and how the barn related to Warren Brown's life. And we determined that the barn did not play an important role in his life, at least not enough. And if you add that to the fact that we don't understand how important Warren Brown was to the community, his contribution to the community, it was very difficult to determine the significance of this structure. When you step back and look at it architecturally, there's one thing about the barn that struck me, and I've been there 3 times. I was there once before the hearing and twice afterwards for a follow-up, is that the roof mimics that of the house. That was the one thing that was unique about that barn. The second thing is something that I mentioned in passing, which was picked up and it was discussed at the hearing, the appeal, and that was the Swiss chalet style. And the reason I said that was because the balusters, which are present on the deck and on the balcony of the barn, mimicked a Swiss chalet style. But when I went back to take a look at it, I looked at the house, and this style of house, in the date in which it was built, the deck was not a common item that you'd have on a house. People didn't put decks on. That wasn't until the 60s through the 90s, and still put decks on. But looking at the construction details, that is not a detail from the 19-teens. It just isn't. That's a detail from the 70s through the 80s. Could have been even later, I'm not really sure. And the deck was added. You could see some of the details of the wood where it meets. There's new wood and there's old wood. You can tell by the finish. And they actually put the plate of the deck across an existing window. So it was added much later. You can barely see it in this photo. It's dark under there, but it was obviously added much later. And I think at the same time, they wanted to do, somebody finished the interior of the space, and they wanted to put a balcony, and they put sliders in, and sliders are not original to this structure either. It's not clear what this structure was when it was built. It was listed as a garage, and then later in the tax records it was a barn. So I think it depended on who looked at it, and then they wrote down what they thought it was. And it probably was being used as a barn by the time these other inspectors looked at it. It's been modified over the years. It still had its original siding. This is all original siding. When I first looked at it, I didn't think it was, but further inspection, it certainly was. It was in fine condition. That was one of the issues the neighbors had. I called that out. I asked Mr. Sang directly, why would you write down that it was in poor condition or a threat to the public when it's in fine condition and it had a relatively new roof? And they just couldn't answer that. But we couldn't base our decision based on the fact that he wrote down that on his application. We look at it strictly as is it historically significant to the town of Amherst? We went through each criteria the second time around. We discussed it at length, and we wrote in our decision we wrote in the remand in some detail each particular section of the bylaw, and one in particular is probably the crux of the whole problem. It's 13.4102. It's number 9 in the decision on remand that we submitted. And that was a discussion about Warren Brown and his importance to the town. And based on the evidence that was presented, we listened to extensive testimony. We were unable to determine that Warren Brown made significant contributions to the town. He may have at the time he was living, but we do not call it the Warren Brown House. It's not on the historic register, and there is some discussion on the Historical Commission to try to place it on the historic register. And it may be included in the new historic district. But it's not known as the Brown House. The barn also was not readily visible from the street. The land, at one time it was more prominent on the street, but the landscaping has been allowed to grow up. So most of the commission members didn't even know the barn was there until they drove by and took a careful look at it. So we did give this careful consideration. I think we spent 8 or 9 hours in meetings. We spent additional time. Meg Vickery, who's the architectural historian, did additional research for the commission. I went back. I went initially once, and I went back 2 more times to look at the property to get a better sense of the barn and how it related to the house. So we spent, I think we've done our work on this particular decision. I think we made the right decision the first time around. You know, some of the criticism and grievances were correct. I think that Patricia Stacey was not notified. That was an error, but it wasn't an intentional error by staff. We do due diligence on every one of these, and I've been on maybe a dozen of them over the years, and we have always taken our time and done the best job that we can with the information that we have. And that's basically it.
Thank you, Mr. Hankey. I had a couple questions for you. I don't know if other members of the panel do. One relates to the assertion that there was a misleading or false statement provided on the application for the demolition permit, specifically that the applicant stated that he wanted to remove the barn to increase garden and lawn area, and then subsequently filed an approval not required subdivision plan. I saw some discussion of that in the minutes. Does that tie in any way with your thinking about the application of the criteria?
I suppose it could, but in this instance, it really didn't, because the bylaw is clear, and there's no line in there that says, is the applicant going to subdivide the property? I mean, in the hearing, in both hearings when Sung was there, I did call him on the carpet and asked him questions about that. But it doesn't say in the bylaw if you're saying the reason for taking it down is misleading. We're going to disregard that anyway. We're not looking for your reason to take it down. We're looking if it's historically significant and if it should be preserved. There are all kinds of reasons for taking things down. I don't know if there's any other laws which apply to the fact that he did not put down a legitimate reason. Maybe it was legitimate in his mind, but I think it's a stretch, and I think it's misleading. I mean, it's just to fill in that particular line on the application. I would have left it blank if I was him, but that had no bearing. I mean, we are concerned about this property. We're sad that he purchased it, basically. You know, that ultimately he took the barn down when there's no real reason to do it. And we would try to prevent that if we had determined it was a historic structure, but we never even got to that point.
And that relates to my second question, and I'm looking at section 13.36. which provides, if after a hearing the commission determines that the structure is a significant structure, as provided under the criteria, and that the proposed demolition would, quote, be detrimental to the historical or architectural heritage or resources of the town. So is it your practice, if you determine a structure is not a significant structure, you never reach that next sort of finding?
Correct.
Okay.
We have to first determine, and then even if we do determine it's significant, sometimes we don't impose a delay. It depends on the circumstances. Typically, if we do find a structure significant, we'll try to work with the applicant to preserve it, and we have a year to do that. Sometimes it works out. Unfortunately, more than not, it doesn't. The one particularly recent success story was with the Survival Center. They had a very nice barn of some significance, both visually and historically, and we did not issue a delay, but we wished that they would preserve the structure in some way, take it down and sell it. Well, they reincorporated the frame of the barn into the center of their new building. So that's an instance where it went through the process and it was a successful outcome. Not perfect, but better than it could have been.
Thank you. Any other questions? Ms. Greenbaum?
Yes, I'm interested in the appeal process, which seems to be problematic with this section 13, even though it's part of the bylaw, as Attorney Bard mentioned. The appeal process seems to not be part of the bylaw, if there even is one, and that for me is the crux of, is there an appeal process or not? So I guess my first question towards that end is, on September 17th, when you sent the letter of your decision to the building inspector allowing the building permit, demolition permit be granted, were the abutters also notified? I did not see any CCs at the bottom of that letter that included any of the abutters.
Well, that's handled by staff, so I don't really have a knowledge of that. I mean, the appeal process doesn't make any sense. Obviously, everyone knows that. If the appeal process worked the way it should work, that barn would probably still be standing and someone would have moved it. That was not available at the time of the original hearing. But had the appeal process allowed for the building to stand, prevent the demolition, then we would have had more time, and maybe someone would have come forward to say, I want to take the barn. But we never got that far. So the appeal process, yeah, there's a flaw. There's a flaw there, obviously, because if you have to wait to appeal until the demolition permit is issued, then you don't have a lot of time to appeal. So it's sort of like the cart before the horse.
Well, that's why I wanted to talk later more, but now is not the time to talk about it. The nexus of section 10.1 and section 13. That to me seems to be the big issue. And at this point, no, the neighbors were not notified at the time the building inspector was.
No, believe me, we would have rather have had even the historic significance aside, we would have rather had the barn stay there. It's an outbuilding, and it's just a shame that, but we have to be fair the way we apply this bylaw. We just have to be fair. We have to apply it the way it should be applied. The appeal process needs to be fixed. I don't know how to do that. I don't know who does that or how it happens, but.
It's a flawed process.
Oh, it is definitely flawed.
It's our job to try to figure out how to apply it despite its flaws, or else tell the planning board needs to be fixed.
Mr. Airgood?
Mr. Hankey, so I recognize that this decision is more complete and with more description, more information than the original. At the December 20th hearing, I had two issues that I thought warranted, for which I thought remand was appropriate, and so I'd just like to, before you get away from the table, to pin those down. You've addressed, of course, the main one that I was interested in, which was 13.4102, and there the commission originally had found that he was a person of some significance, that Warren Brown was a person of some significance without really qualifying that exactly, and hadn't made a specific finding. I didn't find a specific finding about whether he let me put it this way, he's identified, whether the barn was identified with him. And I just want to, you've indicated that you found, that the commission found on remand that even regardless of how important he may have been, and it's unclear that he wasn't, that this was the barn. And I think you even didn't even find that the house was really associated with him. And I think you found that the barn was not associated with him.
Well,
I'm not putting this very elegantly, but I just want to be very clear on this point. In the discussion where Meg, I'm sorry, bear with me one second.
all right.
So, Meg
Vickery.
Petrie?
Vickery.
Vickery, Meg Vickery. She said that even if Mr. Brown is historically significant, the barn as a structure is not associated with him. That was a direct statement. Does the commission's decision reflect that view?
Well, I think it's a little subtler than that. Obviously, the barn was associated with him, but did his actions relating to the barn contribute to in a significant fashion, the history of Amherst? Did he do something in that barn which was historically significant? The fact that he had a barn is not, because a lot of people in Amherst had barns and had chickens and goats and pigs and whatever. So he was associated with the barn.
I'm sorry, I used the wrong verb. It's identified with in the
Okay.
in the bylaw.
He obviously was identified with the barn. It was his barn. If we were talking about the house, we wouldn't be here. If we were holding a demolition delay hearing for the house, it's almost sure that we would find it significant and impose a delay. But the barn, being associated with him and not with any specific event or with, for example, if it was proven that Robert Frost had an office there and had written some of his literature there, then we would probably find it a significant structure. But the fact that Warren Brown owned it is not enough. Even though he's associated with it, identified with it, it's not enough to warrant us finding it as a significant historic structure.
So I appreciate that, but I'm sorry you're making it a little difficult for me, because 14.102, and I don't mean to be offended, 13.4102, there's a finding. Is the barn identified with a person who had some influence on society? And your finding was no, 3, and abstain 2. So if you could restate this finding consistent with the negative finding. I mean, the question is, of course, he's associated in some way because it was his barn.
Yeah.
He's identified in some way because, well, it was his barn. But the question is, the Webster house is identified in some way with Daniel Webster in a way that whatever I think you have found, your finding is to the negative. Your finding is that the barn is not identified with Warren Brown for purposes of this 13.4102 finding.
Well, it says who had some influence on society.
Right.
So we're not sure about what his influence on society was, and we have to interpret this, and it's our interpretation. Our interpretation is, yes, it's identified with somebody, but it doesn't have any significance. I mean, you could have a tool shed identified with somebody, and does it warrant a demolition delay, or does it warrant being found historically significant? And that's the difference we have. I mean, this is not a perfect bylaw, let's face it. I mean,
Right.
We get frustrated by it ourselves when going through it. Some of it doesn't really make any sense. Some of it asks similar questions that are so close together, it's difficult to make that determination. So here, we take this to mean that it has, as a structure, it has some significance itself in relationship to this person.
Right.
And here, we couldn't even get to the point where we understood how significant Warren Brown was. So that's why we found a negative finding on that particular issue.
Okay, so thank you. And now, just the second issue, I think we can be more faster on it. This question of Swiss Chalet. I think it was raised as, well, if it's Swiss, you thought that Swiss chalet means originally that means it couldn't be historical, but then we heard from testimony that Swiss chalet could be, but I understand that what you said is whatever this Swiss chalet was, it wasn't historical Swiss kind of chalet.
It's not it was not Swiss chalet.
Right.
The balusters reminded me of a Swiss chalet style.
Right.
About the same time this house was built and earlier, there is a style. There's one example of it in Amherst. It's in terrible condition. It's owned by a landlord who rents to students. It's down on Route 9. It is a pretty nice example of Swiss chalet style. This is not. This was somebody's idea to make that deck look more romantic than it actually was.
And so regardless of whether it was Swiss chalet or not, you found that it wasn't an historically significant structure.
Yes.
Right. Okay. Thank you.
Thank you very much.
You're welcome.
Now, for the remainder of the evening, we need to hear from Ms. Stacy. We need to hear from representative of the owner, Attorney McConnell. And we also need to hear from the public who've been waiting a long time to speak on this matter. One member of the public approached me earlier about needing to leave early. I'd like to hear from that person with your permission, and then we will turn over to your statement.
Mr. Chairman,
Yes.
if I may, I hate to interject, but just briefly, I just would like to make a suggestion, make it somewhat strongly. Both you and Mr. Henke referred to some of the procedural and formal issues that had been raised both here and at the Historical Commission. I feel as a matter of law, they have all been cured by the Historical Commission's full hearing. They had an option, by the way. Mr. Henke didn't mention it, but I gave them the choice of, I didn't give them the choice, but it was my opinion they had two choices. One was to have a very narrow hearing of just those new issues, or to reopen it and start from scratch, and they chose the latter. So given that they held a public hearing from the very beginning, heard from any and all people who had any interest in the matter, I think all of the formal issues that you had alluded to earlier have been wiped out. And so I say it so that I hope that none of the speakers will spend any time on that, because I think they're dead issues.
So those issues, just to reiterate, were the issue of notice, the butters list that was used to compile the list for notice, the open meeting law issue, and the Historical Commission's not reopening the hearing.
Correct.
So in your opinion, those issues have been cured?
Exactly, because
okay.
they reopened the hearing, everybody got notice, and I've not heard any mention of open meeting law violations. So the whatever happened before became irrelevant. We're now reviewing the results of that most recent hearing, and so they're all dead issues. Nobody can say they were harmed by the earlier events, and frankly, if they want to say it, they'll have to say it to a court, because it's been fully resolved here in the Amherst administrative proceedings.
Okay, thank you. In light of those comments, I would appreciate if members of the public, when you make your comments, if they could focus on the substance of the Historical Commission's decision and not the procedural issues that have been resolved by the remand. So please, Ms. Rubenstein. Thank you for your patience.
Just going to make it in time. Lisa Rubenstein. I'm a town meeting member in Precinct 10. And I just wanted to talk about the process more than anything. And after listening to, reading the minutes of the various meetings and listening to the presentation tonight, I still feel the process has not worked in the way the ZBA hoped it would. And I will explain why I feel that. As a member of the public, I assumed, and maybe this is a false assumption, that a town board hearing a demolition delay would have some prior information as to the history of the property, and have some members, not all, that's impossible, but have at least one or two members designated to do some independent historical investigation. From reading the minutes of the Historical Commission on September 4th, town staff gave a one-sentence historical report that stated, the house and barn were built about 1910 by Warren Brown, a notable businessman and historian. No commission members reported on their own knowledge or asked town staff for elaboration. So I'm assuming the background they have is this one sentence. During the hearing, conflicting evidence was presented by the applicant and the public attendees. In going over the guidelines the commission used to arrive at their decision, I can see that without follow-up investigation of the evidence, the commission members could only regard any evidence as hearsay. And I kind of feel that continues to this day from the testimony of Mr. Hankey just now. To validate the claims of either side at the hearing, it seems reasonable that a decision should have been delayed to a future meeting instead of being voted on at once. So now we come to the ZBA, who remanded the Historical Commission's decision back for reconsideration. And the ZBA made a series of recommendations based on new evidence presented at the ZBA hearings. However, in examining some of the statements made at the February 19th hearing by those on the commission, I do not see a rigorous examination of new historical facts. Instead, the comments of the commission reference the Amherst they are familiar with, as the following quotes show, and this is directly from the minutes. Number 1, the house and barn visually relate to each other, but it is hard to place Brown in Amherst's history. When the house was for sale for many months, it was never referenced as the Brown house. And my question is, if the seller does not know the history, does that mean the history is no longer valid? Number 2, the public's argument about, one member referenced the public's argument about the agricultural nature of Amherst. And they did not feel that this barn, which was set amidst trees on a busy residential corner, could be seen as reflecting that agricultural character. And my question is, when the house and barn were built, this was not a busy corner. There was no Southwest dorms, and UMass was an agricultural college with only a few thousand students. So if the area no longer looks as it once did, does that mean structures from the past have no value? Number 3, another quote from the minutes. Mr. Brown was a writer and businessman, but at that time everyone wrote in journals, newspapers, etc., because there was no email or blogs. I can only comment that not every person who wrote in the early decades of the 1900s achieved widespread attention, as referenced in the evidence presented about Brown and in certain books where he wrote essays about Amherst. Referred to as the Calvin Coolidge of Amherst. I mean, that seems important to me. But that's only my opinion. Number 4, he rides his bike along there regularly, this is one of the commission members, to work, and had not noticed the barn when it was there or when it was gone, in part because of the trees, the color of the barn, and it was not as captivating as other structures in the neighborhood. My question is, are the observations of those who have lived in the neighborhood for over 20 or 30 years worth less than someone who passes quickly by on his bike? And the phrase, not as captivating as other structures, seems to be a value judgment. I do not question the qualifications of the commission. They are hardworking volunteers. My question is, how are they preparing themselves for a hearing so they have a context in which to regard evidence that is presented? What are the standards they are using to measure the evidence they hear? And how are they balancing conflicting evidence? Because these questions remain, I feel remanding the decision back to the commission did not accomplish what the ZBA intended.
Thank you very much. So I'd like to hear from Ms. Stacy, and then we'll give Attorney McConnell an opportunity to speak, and then Stacy, you'll have a chance for rebuttal, and then we'll hear from those in the public who wish to speak.
Just, okay, I have a statement here, and I'll just pass out a few copies of it.
Certainly.
go over the major points I think I just wanted to tell you. I'm happy to quickly skip over some of it.
Do you, excuse me for a moment, Mr. Bagg, do you have a copy of this
No.
document, or Mr. Bard?
Okay, I think.
Thank you.
And, I haven't seen this document.
That's a problem.
So I think what would be helpful, I mean, there's a request from Ms. Greenbaum to take a recess to read
Unless she wants to read it.
this document. But if you wish to read it into the record, and that would solve one of my issues, which is that we don't seem to have a copy for Attorney McConnell. So if you want to take us through this document and have it read into the record, that would be fine.
I'd be happy to do it either way.
Okay.
I can, I think I have another copy if, for the attorney, or I'd happy to just read the document.
Sure, let's go through it.
Okay.
Thank you.
I don't know how much time we want to spend on talking about the issues prior to the remand. I know that the town attorney suggests that we not. There's just a couple things I wanted to quickly go over, however. Regarding not receiving notification.
I think that issue has been
Right.
resolved. I do believe we made a determination that notice was proper on the December 20 hearing, and then we have an opinion from council that if there was an issue, that it had been cured by the remand. So I just think, in the interest of time, if we could focus on the substance.
Right. And I'd happy to do that. I just wanted to ask, I know the general laws are a little bit different than the town laws, and the general laws, require that there be a certification and a list of names and addresses, and they use that language. I didn't see any sign of any kind of certification or signatures or anything like that. So I just wanted to, I'm saying this not to beat a dead horse. I'm just actually as a plea for future processes, perhaps, to maybe to go more smoothly. Unfortunately, though, I do believe that the results of that prove to be irrevocable, of irrevocable harm done, because I think things would have turned out very differently if the Historic Commission had been able to hear my evidence at the original hearing. Okay. I still believe that my right to a fair and effective hearing and appeal process has been denied to us. And I say this with all due respect to the Historic Commission, and I know that there are very hardworking people on the Historic Commission, and I respect them. I don't in any way mean, as you said, also to malign them. I can see that they were offended by what was said in the original hearing, and I'm very concerned about that, because I think that the process itself has led to some kind of a snowball of unfortunate consequences and decisions. Now I'll continue. I'll just continue with this then. I know that you wanted me to read it for. The Historical Commission failed to fully act in good faith during the appeal. In particular, one, several members were disinclined even to hear the appeal, notwithstanding that the original hearing was fundamentally flawed because of the failure to provide me with a proper notice. This was assertions that were made in the public meetings in January. Two, the Historic Commission discriminated against Laura Levitt by not allowing her to vote on the case because her views had already been submitted, while other members had publicly aired their opinions outside of the formal hearings and were allowed to sit in judgment. 3. There's little evidence that the Historic Commission seriously considered the majority of new evidence. And with respect to 3, I have some examples. While 6 votes were cast in favor of various criteria on September 4th, the first hearing, showing that members thought that the matter had historical importance, that vote was reduced to 1 vote, 1 yes vote, after extensive evidence was presented that could only buttress the initial findings of these 6. And I have, you have all this evidence, but I can just easily pass this to you that shows you the votes.
They already have it. It's not
You
necessary.
have
I
the votes.
think it
Okay,
was
so you know
included.
that there were 2 votes for 134100, 2 for 134120, and 2 for 134121. I just have these. I can just pass them on if you want. They're right next to each other. Is that helpful to you, so you don't have to rush through?
Is this a chart showing the votes from the initial?
Yeah, it's both.
Um,
So, you might as
Sure.
well just, take the other ones, but you can just, it's got the first vote, and then the second votes. And you can see the number goes down from 6 to 1. Okay, B. While Brown was widely recognized as an historic figure because of his writings, etc., as strongly supported by the evidence, various Historic Commission members ignored this evidence and focused only on his day job as a real estate agent. The analogy to Mr. Sang, see below, who is only a real estate agent and has none of the credentials of Brown as an historic figure, makes this clear. And you'll see later what the quote is from the Historic Commission. And finally, C, say, note the dismissive remarks of some members. Okay, and here I go into more detail of the above-mentioned items. The Historic Commission largely presented their own evidence in favor of demolition rather than weighing all the evidence. Thus, the exercise was a tautology. A, unequitable recusal of one member of the Historic Commission. Professor Laura Levitt was asked to recuse herself for showing bias toward the barn's historical significance, a bias that was not more than a difference of opinion from other members of the Historic Commission who showed significant and equally biased opinions prior to the second hearing and still were not asked to recuse themselves. Okay, example 1. The Historic Commission chair had written an op-ed piece on the subject and had already denied our request for reconsideration, exposing an opinion not unlike Levitt. Why was his opinion not grounds for recusal? Example 2. Commissioner Cornell expressed utter contempt at the notion of rehearing the case in the January public meeting and defended the assertions in the op-ed piece that had been written by Mr. Hankey. Okay. All right, I've already discussed the 6 votes reduced to 1. And I'll just skip to, logic suggests that based on the preponderance of new evidence, the yes vote for criteria would likely increase rather than diminish the yes votes at the original voting process. And I explain what the votes were, which I just have done, so I'll skip that. This discrepancy shows that the process itself is arbitrary, subjective, and was biased toward a no vote in the second hearing. Otherwise, the votes would have been comparable or indeed further in favor of the extensive submitted evidence. And I just have to stop here and ask you to make sure that it's my understanding that you've read the submitted evidence that we submitted. Okay.
Yes.
That's good. Further proof that the Historic Commission did not weigh the majority of new evidence, the one-sided argument. Okay, so one example is the new evidence submitted that we submitted contained evidence pertaining to the historical importance of antique barns throughout the United States, New England, and even in the Pioneer Valley, as exemplified by Hadley's comprehensive barn survey, which was conducted 5 years ago. Yet none of the information was discussed in the deliberations regarding the historical importance of this barn. Indeed, rather than weighing that evidence that was offered about such importance, the commission pulled out one obscure quotation from that evidence about the importance of land around barns and used that one small quote as the basis, in fact, for their entire position. And I say position here, I mean it was a position in the sense of I would just say showing a bias. This is not a logical deliberation weighing all evidence. It is a one-sided argument. Okay, and here is from my notes of the hearing. Mr. Cornell says, Meg, didn't you have something on the agricultural stuff? And Meg says, oh, yes, I do. She goes to pull out this one small quote, and I think that you did, if you did read my, the report that I submitted, it had information from the significant information from the many briefs from the Department of the Interior and from Mass Preservation about the importance of historic barns. So you probably have some insight into the way they're thinking about what barns are, what would make a barn important. And she says, oh, yes, I do. She reads the quote about how land around barns is important, and then says, well, this didn't have land around it, and thus states that thus the barn wasn't important. This goes completely counter to virtually every other piece of evidence from the Department of the Interior and from Mass Preservation. And again, it's which was not weighed. And I think that that is something that Alyssa mentioned, and I agree with her very much so. There was a sense of there was not a sense of a weighing of information in the deliberations, especially not the weighing of the new information that was submitted. Okay. Further proof that the Historic Commission did not weigh new evidence occurred during deliberations about historical and geographical importance of the barn. Several longtime residents spoke with passion and conviction to the Historic Commission about the geographical significance of the barn, indicating that it wasn't a, quote, established and familiar visual feature of the neighborhood. 27 appealers signed the appeal, making the similar claim. This information, though, mentioned by one member briefly, Linda Fay, was quickly dismissed by others. They focused rather on the foliage, the fall foliage that covered the barn, made it harder for them to see from the street. Now, I had explained in my presentation to them that they had viewed the barn themselves. They apparently were not familiar with the neighborhood. They'd viewed the barn at the time of the hearing, which was in fall, a late summer, early fall, and that when there's in winter and spring, you can see a tremendous amount of that property because there's no foliage. So, but there was no mention of that evidence of ours, and really almost no discussion whatsoever of our convictions, our evidence as to the barn being a local landmark for our area. Many people say turn at the barn as a as a local landmark. That was questioned by someone who just decided that we were being disingenuous, and in fact that it wasn't true. He assumed this based on his riding by the barn on a bicycle once in a particular season, and we took offense to that. We didn't see that as a proper weighing of evidence. Okay, finally, and I think that this is, of course, finally, because I think this is the most significant part of the problems in the procedures, was the evidence of Warren O'Brown's influence on society was not included in the deliberations. Okay. In my opinion, and I say this with all due respect, this particular deliberation proved the most egregious in omissions of both of evidence and logic. The assertions of historians were plainly laid out, which we plainly laid out, the arguments in the appeal to the Historic Commission, and which you have all read, our discussions of the influence of Warren R. Brown. All right. Criterion 13.4.102 indicates the structure should be considered important if it is, quote, identified with a person or group of persons who had some influence on society. Now, I should stop and tell you that immediately when they began the deliberations, they did not use the language influence on society. This may sound like mincing words, but I found it disturbing and upsetting. They kept saying, well, we have to figure out if he is significant, which maybe means the same thing to them. I don't know. But it was the building that was the significance. One just had to determine if he had an influence on society. Well, on February 5th, Commissioner Vickery had thanked Patricia Stacey, me, in fact, profusely for providing the commission with such comprehensive information and saying, with near tears in her eyes, I have learned a lot that I didn't know about Amherst and its history. And she was very grateful for the presentation, in fact, on 19th. But the climate changed at the next continued part of the hearing. And the discussion of Warren R. Brown grew dismissive. In fact, the tone was very, very different that second hearing. The commission did not adequately discuss or even mention Warren R. Brown's writing career in their deliberations. They chose instead to emphasize Warren R. Brown's day job. While historians of the history of Amherst have compared Warren R. Brown to Calvin Coolidge regarding his influence on decades of Amherst history and society, the Historic Commission chose to compare him to D.H. Jones. And then, based on that discussion, tautologically suggested that Mr. Yupan saying, the developer who destroyed the barn, might by this logic be just as easily and fallaciously considered of historical importance for his development of the neighborhood. This made no logical sense. Historians do not concern themselves with Brown's business real estate work. They are concerned with his writing and public speaking career. Now, I was actually listened with great interest to Attorney Airgood's questions of Mr. Hankey, because I think that you may have seen a little bit in his thinking of what the appealers felt was problematic in the deliberations of the Historic Commission, particularly around this issue of the influence of Warren R. Brown on society. We felt that we had fully proven Warren R. Brown's intimate relationship to his barn. He wrote on topics that were closely connected to animals, agrarian life, and he built the barn, perhaps not by hand. And we felt that the commission was dismissive of this, illogical, and in fact, I just wanted to go on to quote, following our verbatim quotes from my notes of the discussion of Warren R. Brown's, quote, influence on society. Now that's my language, it's not theirs. They did not question at all, ever, in their discussion, did he influence society? They kept using the word, was he significant? But that, as I said, that's minor. Here's one quote from a commissioner. We weren't around back then, so we don't know if he was significant. Okay. No mention of the evidence proffered by the appealers at all. A bit later, one member says, well, there is a suggestion that he was a writer. Okay, this is the first mention of our evidence. Second member. Everyone wrote back then. Everyone has a blog today, and they didn't have them, so everyone wrote. Okay. No more discussion of his writing career. Okay. Now, I am not an architectural historian. I may not be able to parse the finer details of what may render a certain kind of original sighting more important than another kind of original sighting. But I do know, I teach college, and I know if evidence is complete. And I can recognize if someone has influenced Amherst society. And I think that we as a group proved that this particular figure in history influenced Amherst society. I think it's irrefutable. I fully expected that they would vote on the basis of the new evidence that he did influence society, and expected that that what they might do is say that they, in perhaps a kind of compromise, say that they would not allow a delay. I thought that would be logical. That was not what happened, and that disturbed all of us profoundly, because to me it showed bias and was disrespectful to our whole enterprise, which we have spent hours and hours on this. The commissioner said they spent 10 hours in meetings. We have spent over 100 hours, maybe even 2. Why would anyone do that? I mean, I ask you. It's because this is a significant building to us and issue. Okay, so finally, I'll finish. I also think that just this statement, everyone wrote back then, everyone has a blog today, and they didn't have them, so everyone wrote. This we all know to be a false statement. This is not true. In fact, the opposite is true. I've heard writers from even as early as people who were writing and having influence on the public, even from the 70s, say that one has less influence now as a writer because there are more voices. Warren O'Brown was a significant voice, which the historians have asserted. Okay. Okay, here's another quote from the commissioners. It's ironic that he was a developer. He helped develop this neighborhood, that neighborhood. It would be like honoring D.H. Jones or even saying for what they've done. I said that one. Okay, so just to recap, there was no discussion of Warren O'Brown's, quote, influence as described by historians. No logical or meaningful weighing or even mentioning of the majority of submitted evidence on Warren O'Brown. No presentation of logical criteria for the voting process to determine his influence on society. And I wish to repeat that I think you saw that there's a tremendous amount of subjectivity in this process, which was asserted by Mr. Jim Wald in his discussion at the Historic Commission. And we all know this. The criteria are extremely broad. And my interpretation of the criteria is that the framers of it were trying to give every possible opportunity for people who wish to save a structure, to save it. But we have a commission, and they make their own decisions. It's the logic of this particular decision, I think, denied us due process. We feel that our right to save a valued historic building has been denied, both by the town's process of forcing us to appeal at a point when we had no power to save the barn, and our right to a fair rehearing has been denied, because I think Thomas Wolfe famously said, "You can't go home again." And I think that has been borne out in this process, because I think there was a lot of emotional baggage that came with this, and I think that there was, as I stated actually earlier in our discussions, that I felt that going back to the Historic Commission would render them in a position where they could professionally would really be needing to defend an original decision. I didn't hear, I just want to add, I didn't hear any discussion of the information that I presented from the Department of the Interior or the what is it called? I don't know. The Massachusetts Preservation Society too, which was unfortunate. Finally, we looked to the ZBA for remedies and for changes in this broken system, which allowed a demolition with no consideration to our rights to conduct a meaningful and effective appeal to a demolition permit. Now I finished that. May I address just a couple things that were said by Mr. Hankey?
I actually had a couple of questions, and
Okay, sure.
I would prefer if we sort of stuck to the substance of the decision. And I just want to make sure that I understand that your argument is essentially that the Historical Commission sort of undervalued Warren Brown's importance to Amherst, and I'm looking at specifically because it's section 13.4102, which says whether the structure is identified with a person or group of persons who had some influence in society. So I see your argument fitting there, and then it seems like it also addresses the geographic importance of the structure.
Yes.
I just want to make sure, because I'm trying to understand your argument in terms of the criteria.
Say that second one, clarify that.
Well, I'm just, it seemed to me that based on the presentation, that there's an argument that the Historical Commission incorrectly made its decision rather, based on sections 13.4102 regarding Warren Brown's influence on society, and I guess the extent to which the barn was identified with him. And then its geographic importance under, this would be section 13.4121. And I just one other question, because I want to make sure that, I think, again, as I said earlier, part of the reasoning, at least for my part in the remand, was to make sure that you had a chance to get all the evidence in front of the Historical Commission. I want to verify, sort of make sure that happened for you during this remand.
I presented written testimony. I didn't hear evidence in the, I presented it all in front of them, and that was somewhat satisfying, but I heard little evidence and read little evidence that my evidence was weighed and considered, and I did not leave with a sense of why my evidence was not weighed and considered, and what of my evidence they would have found, why they would choose a no as opposed to a yes after I presented my evidence. I still don't know. And I did not have the benefit of which Attorney Airgood had of being able to ask more questions of why are you thinking this way, because as you know, the way the process works is you present evidence and then you fall silent during deliberations. So there wasn't an opportunity to say, please clarify, what is your thinking here? Why are you ignoring this evidence? What do you mean he's, what do you mean he's not, I don't mean to sound disrespectful. I did not hear what I presented taken seriously or weighed. Some of it, there were two minor points that they discussed. They did discuss the Swiss chalet issue. I had in my presentation said that it was likely that it was put on at a later time, and that it was reflective of an older style, and that the mass preservation people felt that that was actually a really interesting part of the life of barns. They addressed it in a more kind of as an argument for why it wasn't an important, which I can understand. Architecturally, maybe they don't like that. They don't value that. Mass preservation values it, maybe they don't. I didn't hear them explaining that. I mean, I can infer certain things. But am I getting at your question?
Yeah, I just wanted to make sure that you'd had a chance to get your evidence in front of the commission, because again, that was, I think, an important part of the remand process. And it sounds like it was presented and perhaps not weighed in the way that you thought was appropriate. But you did answer my question. I think Mr. Aragood has a question.
Well, I'd like to say that I respect very much the presentation you've made, your statement. There's a reference to broad criteria in Article 13, but it's not just broad, it's worse than that. Basically, I think this turns on 13.4102, which says, just look what it says, is identified with a person who had some influence on society. Now, what in the world does that mean? That's what we have to decide. Can it be a little stick in the ground that's identified with some important person? Is it identified at the time when it was happening? So what you have here is, and what you're expressing your frustration with is, so many of these decisions of this type are made by volunteer boards, dealing with criteria that aren't clear, with, how would I say, with kind of a flexibility of approach that is natural for volunteer boards. And in this case, you have a very great interest in it. You've tried to, you've put in front a lot of information. I'll just say the standards of review that we have, it isn't, do you take 100% of the evidence that was put forward, and do you have to judge, exactly, how is it all perfectly well weighed, and do we make a decision that, that it had to be exactly this? So there's really an imperfection in the process. If I don't end up voting in favor of the appeal, it's not because I don't respect. It's not because I understand what you're doing. I want to say I appreciate the efforts that you've made and recognize what a process it is that you've gone through. I'll just leave it at that.
Ms. Greenbaum?
I have two questions for clarification. One, follow up on Mr. Beal. Did you present the evidence in written form, or were you also allowed to comment on it? Did they just get it in written form, or did you comment on it also?
Yeah, I was able to comment on it.
Okay, so they knew what you had given them.
They did.
Okay. The second question has to do with recusal of Professor Lovett. And it is my understanding that Ms. Lovett came here to the zoning board as an abutter, and that when it was remanded to the historical commission from discussions with Attorney Bard, that she would not be allowed to sit on the panel of the historical commission because she was a butter, not because she had an opinion or a bias on the case. So I just wanted to ask that question, if my memory is correct, and clear up that fact. I don't know whether she lives in 300 feet or not, but she did come to this board as an abutter?
I don't think she's technically an abutter. She did live, she lived in the neighborhood. She no longer lives in the neighborhood, but I think she knew about the barn. I think she came, as an historian, interested in it, as well as someone who lived in the neighborhood. I don't know what hat she was wearing when she presented.
Because I know we did have the discussion here about whether she could participate in the hearing of the Historical Commission. Because I know she was cut off in mid-sentence of trying to present her evidence to our board, and I did feel very badly that she was cut off and not allowed to continue, because we were remanding it, and I hope that she was able to give her information to the Historical Commission.
Mr. Aragood may be able to shed
I
some light on
don't
this.
believe it's so much a matter that she was cut off, but she made a very powerful statement against the original decision of the Historical Commission. So that would, that's different. For example, when Mr. Hankey made the decision, when you make a decision one way and then you take it in the next appeal stage, that's not it's not a it's not a statement. It's not a statement of bias. It doesn't count in the same way as
Right.
what that
So
is.
if I could just jump in, I think that there's another element of that too, and I will also defer to Mr. Bard, but my general understanding of it was that on September 4th, during the original public hearing before the Historical Commission, Ms. Lovett appeared as an abutter or a resident in proximity.
Oh, ma'am, please.
Okay, so
Please. Thank you.
let's qualify that as we go, but she came to the public hearing for the first session, and then subsequent to this, which is where perhaps town council and staff have more of a concern, is she subsequently became a member of the Historical Commission who would then participate on this decision. So I will happily defer to Mr. Bard
Well-
if there's more to it, but that was where the distinction that I saw at least.
Frankly, I'm uncomfortable with this whole discussion. Ms. Lovett voluntarily recused herself. Somebody cannot be recused. She recused herself. I hear people saying under pressure. I don't know. I think the important thing is that as a member of the commission, she recused herself, did not participate. I really don't think we should prolong this discussion. This was a decision ultimately an individual made who's a member of the commission.
Please, ma'am, excuse me.
You are hearing from town council, and town council is telling you that I had conversations with Ms. Lovett. She voluntarily recused herself, and that's the end of the story. I certainly didn't apply any pressure, and I will say this to anybody who sits on any board in the town, that someone recuses themselves because it may or may not implicate questions of having a conflict of interest. If somebody has a conflict of interest, they are violating state law, and so whenever anybody asks me a question, whatever the facts are, I'm very clear about that fact, that this is a matter that they should take seriously. It's not a reflection on the board, it's a reflection on them personally if there's a conflict. And as I said, that's my routine advice, no matter who I'm talking to and what the facts are. And Ms. Lovett recused herself. So, I mean, there's really, it is frankly, in my opinion, inappropriate for people to be commenting on the recusal of a member from a board, and I would respectfully suggest that we move on to another topic.
Thank you, Mr. Bard. And I just want to say that I cannot allow this hearing to become a free-for-all, so please restrain yourself. I know feelings run high on these hearings, but please restrain yourself from shouting out comments. And I don't know if you have any further comment. If not at this point, and you will have a chance to for rebuttal. I would like to give Mr. McConnell a chance to make a statement, and then after your rebuttal, I will hear comment from the members of the public. Thank you.
Are you asking me to stop?
No, I
would
mean,
like
if you want to make a closing statement, that's fine. But I'd like to move along.
Yes. I think it might be important if if the members of the zoning board would consider continuing, I think we're going to probably have to continue anyway, but asking Professor Lovett to testify as to whether or not she recused herself.
Your request is duly noted. I do have one further question, which is what remedy, if you were successful in this appeal, what remedy are you seeking? I would note that in one of your papers, you'd requested several sort of remedies having to do with the property that I think I noted in our December 20th hearing that are really beyond the purview and jurisdiction of this board. And so I just wanted to give you a chance to articulate what remedy you think would be appropriate. And if you don't, I don't mean to put you on the spot. If you want to come back after Mr. McConnell speaks, that's fine.
Would whatever remedy that we would ask for, would that have any bearing on your voting decisions in this case?
It's different from there's a substantive decision that would be made whether this board would conclude that the Historical Commission had abused its discretion, acted arbitrarily, or sort of made clearly erroneous findings of fact. And then there's sort of another piece that the Historical Commission never reached, which is a finding required that if we found that the building was significant, that we would also have to find that the proposed demolition would be detrimental to the historical or architectural heritage or resources of the town. So if we did that, then it would be appropriate to talk about remedies, but they're two separate issues.
Mm-hmm.
But if you want to let Mr. McConnell speak and then you have a chance for rebuttal.
Okay.
that
I
would
might
be
need
agreeable.
to ask for a recess to think that question through. I just did want to address, I was not, the issue of bias and in terms of the recusal. I need to say that I wasn't arguing that because they voted one way before, that meant that they were biased in the way that Professor Levitt is, although I think logically that is in fact the case. I think there's a lot of evidence that there was, significant attempts to shore up and just defend a decision that was already made. But what I was saying was that in a January public meeting, when there was a discussion, the Historic Commission was very confused about what they were going to be deciding on. They didn't understand. No one told them what happened here at the ZBA meeting, and they were told by staff that one of the things they could even consider was just, did we make the right decision based on what we knew? And there was a lot of outrage that was expressed, particularly by Commissioner Cornell, but there was also an op-ed piece published by Commissioner Hankey.
Stacy, I think I was asking for a summation of your position. I think you're going in a different direction.
Okay,
Let's hear from Mr. McConnell, and again, you will have some time.
That's fine.
That's fine. For rebuttal.
Okay, so I just in conclusion feel that in the entire process that we did not receive due process, and I think that the results were devastating in terms of the effects on the barn, and I think it's fascinating to note that even Commissioner Hankey noted that had the decision gone in the other direction originally, that right now someone would have taken the barn and moved it. I think that shows that it had value to the community, and that due process has not been served, unfortunately. So
Thank you very much. Mr. McConnell. Good evening.
I think that was a terribly unfair characterization of the Historical Commission's hearings. The Historical Commission did not fail to act in good faith. They acted in very good faith. They did not, the allegation was they did not treat it seriously. They treated it very seriously. I was not at the first meeting, so I can't discuss that, but after you remanded it to the Historical Commission, they had approximately 5 hours of hearings.
Mr. McConnell, I'm sorry.
Yes.
I apologize. If you need to have a discussion, a side discussion, please take it outside the hearing room. It's distracting to me to have other discussions happening while a presentation is occurring. Thank you. Thank you.
The Historical Commission did not ignore the evidence that was presented to them. Maybe they didn't agree with what the proponents proposed, but they spent I believe it was 5 hours accepting testimony from the applicants, and a little bit they asked questions of us, but the testimony was presented. I think it was extremely well discussed. They discussed it. They did not agree with everything that the proponents proposed, obviously, and to allege that the Historical Commission and this board did not provide due process to the applicants is a terribly unfair characterization of what went on. The Historical Commission never was dismissive of the applicant or those who spoke in this matter. They were respectful of everyone. They sought information, they asked questions, and they deliberated extremely seriously. They wrote a decision the first time that I thought was quite well written and quite thoughtful. They wrote a decision the second time that I think was just as thoughtful and just as complete. I think there has been no evidence here tonight that the commission acted arbitrarily or that they acted capriciously or that they were not supported by the law. The applicant does not agree with their finding. The applicant would like further discussion about it, but I don't know how long the first hearing was because I wasn't there, but we did 2 nights of about 5 hours the second time around, and I think the evidence was reviewed, the discussion was thoughtful, nobody was cut off, everybody presented for as long as they wanted, and I think that I would urge this board to uphold the Historical Commission's decision. They were not arbitrary, capricious, and they are supported by the law. And I would request that the board uphold the building commissioner's issuance of the building permit to remove the barn. I'll answer any questions, but
Thank you. Any questions? Thank you very much.
thank you.
So, Ms. Stacy, did you want to offer a rebuttal? If so, please.
So that, now it's my opportunity to, well, this is the last time I can speak then?
Normally, our rules and regulations provide for this procedure, and following your rebuttal, I would like to hear from comment from members of the public. That's what our regulations provide for. So you don't have to speak.
May I request a 5-minute recess?
If there's no objection, I don't have a problem with that. Okay, we're in recess. Thank you. So we're back from recess, and so please.
I've been thinking about your question about what would be an appropriate remedy in our mind if you voted in favor of the appealers. And one of the appealers suggests that a garden be built, which was the original plan, as we all know. We had put on the original appeal a request for anything that's built to be in the historic character of the neighborhood, which seems in spirit to be an appropriate remedy. Another possibility would be, in fact, a year's delay of building or any combination of the above. As we've said on many occasions, our concern is the historic character and the loss thereof to our neighborhood.
Thank you very much. Okay. Yes, ma'am. Please, yes, please, as you come forward, please state your name and address for the record. And if possible, given the hour.
I'll be quick.
Yes, I'd
3
appreciate
statements.
it. Thank you.
Judy Seacrest, I'm across, 285 Lincoln Avenue. I'm directly across the street from this. And I will say it can be seen from the street because I can see it every time I go out my front door. You notice I get a great view now of the southwest dormitories. And it was a pretty little unit. I made a bid on this house, looked at it very, very carefully before I bought across the street. I made a bid on it. And I found that I think some of the real irritation is all the misstatements, untruths that we hear, put it mildly. But it does make a big difference to us. And it was advertised as a place where Robert Frost wrote. They said there's no proof of it, but a neighbor said her father delivered papers to Robert Frost and all that. So, I only hear street talk. Mm-hmm. And a woman said that her father had delivered papers there. And I also think that I think some of my irritation was the misstatements, that he was going to make a garden, that the house was in good repair. I was thinking of a studio apartment there. And maybe he should have put a garden in there. I think it was a great idea of his to have a garden there. Maybe that would be a good solution. Anyway, I also didn't think that the statement, I suspect what the statement, rather than Robert Morris said, oh, go ahead and tear it down, I suspect he stated the law as he stated it to me, that there was a glitch in the law. He was allowed to tear it down, but if the zoning board or whatever voted against him, he'd have to put it back. So that's what I think Mr. Morris said. I didn't get to this meeting. I was in Florida, so I didn't hear. All I am is reading the statements as it said because I missed the meeting. But anyway, thank you.
Thank you very much. And yes. Good evening.
Maurianne Adams. I'm a neighbor on Beston Street and a Precinct 10 representative. Is this working?
Yes.
Okay, good. It's obvious that a number of people put a huge amount of time and energy into this, and I mean not only the Historic Commission, the Zoning Board of Appeals, the town staff, the lawyers for Mr. Tsang, and more than a dozen members of the immediate neighborhood. And that we've been concerned as much about the fact of the barn as we have about the principles underlying this decision going forward. So I want to express my appreciation to everybody who has been so deeply involved in this. And I do want to register my disappointment and discouragement. I'm obviously disappointed in the outcome of the decision made by the Historic Commission. But even more than that, I want to just make some observations on procedures, which I think are even more concerning and discouraging for me, having been part of this from the very beginning. You know that Ms. Stacy had taken a request for a rehearing to the Historic Commission at the very beginning, and that they had denied that. And so that is really what has put us into all of this disarray, because once it was not possible to appeal the decision at the historic decision, we had to await the giving of the demolition delay so that we could then get the appeal in a few minutes later, and a day or two later, the barn was gone. So I do want to note what has not been stressed on the record, that there was an initial appeal to the Historic Commission to please rehear or to revisit the decision, and that was denied. I think that was back in September. I also want to say, and I really want, since I'm not a lawyer, I really want to ask some of you as lawyers, that although clearly the Historic Commission had to focus on some very specific criteria, whether or not those are clear criteria, specific criteria. The representation itself was fraught with deceptions. There's not only the statement that the barn was in good repair, which was not true, that the tenants would be alarmed by the barn's existence, which was not true. The tenants have said that they were more concerned about the demolition than they were about the disrepair of the barn. The fact, the intention about a garden. And then finally, the claim made here that Mr. Zhang had not been informed about the appeal, when we know quite clearly that Mr. Zhang had been told about the neighbor's appeal face-to-face on several occasions. So I don't know how, in terms of the law, one deals with this issue of someone coming before a board with a history of chronic misrepresentations. It is troubling to me, the narrow construction that leaves that out.
May I make a comment?
You want to make a comment? Oh.
Certainly.
Because I was asking
At
help
the
from
December
lawyers.
20th hearing, I asked Mr. McConnell and Mr. Bard whether there were any local laws, applicable laws similar to the Federal False Statements Act that make it a crime to make a false statement for the purpose of obtaining something. And I had done some research and found nothing, and I find nothing. And Mr. Bard and Mr. McConnell said there is no such general law. And Mr. McConnell also pointed out that in Article 13, that the criteria that the commission must consider to make a decision don't leave room for that. So I think the bottom line is, as irksome as it is that these kind of statements would be made that don't seem to be accurate, they just don't fit in the legal framework of the decisions that we have to make. Is that correct, Mr. Bard?
That is correct. There is a State False Claims Act, but it doesn't apply to claims of this nature. So that's correct, yeah.
I would simply add a caveat that, in my view, a knowingly false statement of fact that induces an action on the part of an administrative body, that if that were later found out to have been false, I think that there would be appropriate that some type of estoppel apply in that type of case, because the decision then would be sullied by the false statement.
And if it were material, it could be grounds for rescission of the decision. But in this case, as has been pointed out in several comments, it didn't go to the historical nature of the property and the substance, but yes.
Right.
And so I'm mainly making procedural comments and trying to understand procedures and wonder whether there is some way to correct that in the future, because it is very troubling when one thinks that one is working with a body in good faith and in trust and confidence, to know that there is the history of misrepresentations that may or may not be material. It's very difficult in these subjective issues to know what finally is material. So I just want to comment on that as one of the many ways that I've been troubled by the process as well as the regulations. I'm just going to go through these quickly because I know we're constrained for time. I do want to comment very
I'll just
brief-
note that we're not necessarily constrained for time, just so I don't want there to be any confusion that
Okay, thank you.
we have plenty of time.
Thank you. I'm just aware of everyone's endurance
That's
and nerves.
It's 8:30. We've gone a lot longer.
My own included. I don't want to beat a dead issue on this third one, but I do just want to comment that when I was here when Professor Lovett made her comments, and my understanding was that she had come forward as a professional historian whose field of study is indeed this era as well as this area, and that she had made those comments in her role as a professional historian. And it was in that sense that I was dismayed by the recommendation, and she reported it to me, that she had been urged to recuse herself. I just want to note that for the record, since we've had some discussion of that. We may or may not follow up on it, but that did, I think, lead to the absence of a very valuable perspective on the Historic Commission, since the Historic Commission had been increased at that point to include her. I felt that that was a point of view that, in my estimation at least, would have led to a more balanced or carefully weighed, explicit looking at the evidence. There was no written record of the December 20th ZBA hearing, and there is no record of the specific questions that I know, because I was here, that the ZBA members raised. What distressed me in this case was that when the town staff liaison came back to the Historical Commission, there was not an explicit conveyance of what I felt were very clear questions that I had heard the three of you make. And since there was no explicit conveyance of those questions, it was very hard to hear the answer to those questions. I also recall from your discussions on December 20th that after listening to Professor Lovett, you, at least I believe Ms. Greenbaum, had asked, or maybe it was Mr. Behi.
We're easily confused.
Yeah, I know, you really look alike. Yes, but that Professor Lovett had been asked to prepare a brief on her views. I remember that as part of the discussion. Again, because there's no written record, we can't check it. But that also led me to regret her having been asked to recuse herself, because I think we lost that, not only the information, but the authority behind that information in the subsequent hearing. I'm going to just skip over point 5 because we've said a very great deal about it. Obviously, there's a difference of opinion. I did not hear in the discussions the kind of weighing pro and contra of evidence and data that I'm accustomed to as a scholar, I guess, and as someone with very high expectations, even for volunteer bodies who make irrevocable decisions. So I have to say I found it disappointing, and I found that the minutes justified my memory. And I was troubled, I must say, by a statement fairly lengthy by a former Historic Commission chair who commented at the close of the public portion of the remand hearing, I'm at point 7, that these decisions are inherently quite subjective. I felt that that call to subjectivity was an open sesame that did not inspire confidence, given the complexity of evidence we had presented and our expectation that a body sitting in judgment would weigh and balance arguments and data in a fair and open way so that intuitive subjectivity would be outweighed by a preponderance of the evidence. So I'm looking back very sadly on this whole process as one that involved enormous effort of time, good faith, and energy, in which I feel many multiple procedures went awry. And I remember the closing of your December 20th, the public comment, when Miss Stacy asked you as a genuine comment, a genuine question and not a rhetorical flourish, how could she have confidence that the commission would pay serious attention to new evidence that contested their prior decision? And she was asked by you to have confidence in the process. And I've been very disappointed by the outcome, the procedural outcome, even more than the substantive outcome. Thank you very much.
Thank you. Yes, ma'am. I'm sorry, I'm not going in any particular order, so as hands are up, I will call on you. Thank you.
Jennifer Taub. I live at 259 Lincoln Avenue, and in Precinct 10. I'll be really brief, I promise, but for whatever it's worth, and it may be irrelevant, but I just feel I have to state this because it's been bandied about so much, but about whether the statement that the property owner, Mr. Chang, made at 290 Lincoln Avenue, that he was going to take down the barn because it was structurally unsound and he planned to put in a garden. At the February 13th meeting, that was when the Historical Commission was hearing the ZBA's remand of the barn. Meg Vickery, a member of the commission, stated that she would have fought, now this was not her exact words, but basically that she would have advocated more firmly and not have gone along for the demolition delay and not have agreed that the delay not be imposed because the property owner had stated that when the barn came down, he was going to put in a garden. And she said what concerned her more than the garden was that all the beautiful trees remain on the property, that she felt if the trees were to come down and the foliage, that would be a real loss to the community, and that she could live with the barn coming down because a garden was going to go in its place. And she stated that had she known that a garden, that was not the intent, the true intent of the property owner, she would, she would have voted for the demolition delay. I just want to state that just for the record, and that should be in the record of the February 13th Historical Commission meeting. Thank you.
Thank you. Yes, ma'am.
Okay. Yep. Thank you.
Thank you.
My name is Joan Burgess. I'm in Precinct 9, and I am a town meeting member. I would also like to address my thoughts about the appeals process in general. So you're lucky I'm going to skip over all of the information about hearings and the content. This is just a real basic issue I have with the appeals process, and I'm wondering if there's some way that we can fix it. In this particular case, there are three key dates in my mind. On November 5th of 2013, a permit was issued by the building commissioner for demolition of the barn. Totally legal, it was. And on November 6th, Ms. Stacy filed an appeal, or actually the appeal was posted against the permit that was issued. And on November 7th, the barn was demolished. Section 10.1 of the zoning bylaws states that appeals may be filed within 30 days of the order or decision, in this case the demolition permit, and Ms. Stacy certainly did that. She did it within 1 day. In my opinion, and I certainly would like some information on this if I'm wrong, but it seems to me that her rights of appeal were in essence denied because the barn was down was gone before she had any opportunity to present her appeal. And for that reason, I feel that Ms. Stacy deserves some damages for this particular situation. But my real question is how can we stop this from happening in the future? It seems like a catch-22 to me that there's supposed to be a 30-day window when a person can make an appeal, and yet in the case of an irrevocable action like the demolition, the action can take place before somebody can appeal. And so, in my simplistic view, I'm just wondering if there's a way that we can put a restriction in on some permits, or especially if there's any irreversible action involved in them, so that they would have to wait for the 30-day appeals period, and if there were an appeal filed, that appeal would have to be settled before the irrevocable action could take place. And again, I'm no lawyer, and don't even know what bylaw this may affect, but it just seems logical to me.
Thank you. That issue has also been on my mind. I think it's the significant procedural issue before us, and I think we will discuss it, but not right now, but
No, I understand.
hopefully later.
I just wanted to put it forward.
But thank you for articulating it so well. Yes, ma'am?
I'm Paige Wilder. I live in Precinct 10 on Fearing Street. I would just like to get some clarification about some things that were said tonight. The idea that if you knowingly make a false statement that would induce a government body to make a decision might have legal consequences, and that there is this false claims state law. I didn't understand what Attorney Bard said about it being historical and not material. If you could discuss that some more. If someone actually made false statements on the application for demolition, how is that historical or immaterial? If you could just elaborate, I don't understand the terms.
Certainly. Mr. Bard, do you want to take
I'm
a shot
sorry,
at that
it
now?
sounds like I wasn't clear. The particular concern, and we did look at this, and I actually, and I thought I had it in my file, and it probably is in here somewhere, but I can't find it. But I wrote a brief letter or email, I think it was to the town manager, actually, on the issue of how this does it or not fit under the State False Claims Act. And I will locate it in the next few days, and I'll send it to Jeff Bagg, and he can make it available. So it simply that our particular state law doesn't apply. But in terms of, and as the chairman pointed out, if somebody makes a material misstatement and a board or misrepresents certain facts and a board grants a permit, a board can have a recourse on that basis. My point was simply this, that and the point was made well earlier in the evening, I believe, by the chairman of the Historical Commission. A person's motivation, the reason for which they want to take down a building, is irrelevant. Under the demolition delay bylaw, once a person says they want to demolish a building, you look at the historic characteristics of the building, the site, the individuals, and so forth, and that's what's relevant. Their reason for taking down the building has no bearing on the criteria under the bylaw. It's as simple as that. So the fact that the statement was likely not accurate really doesn't have any bearing on the facts that have been discussed here tonight. And that was my point earlier.
Yeah, I think there were 4 or 5 false statements that we clarified in our written appeal, and I didn't hear any of those addressed by any of the boards. And we had asked I don't know if it was the Historic Commission or the ZBA to verify some of that. I think it was at a Historical Commission hearing to verify some of those facts before making a decision. So I never heard any of that. And if we could also have a copy of that state law in this record, I'd appreciate it.
Thank you very much. Any other public comment? Okay, yes, sir?
Jim Wald, Select Board Liaison to the Historical Commission and past Chair of the Historical Commission. I just wanted to say a couple of things because, again, the evening is late and you've covered a lot of ground. What I did regret about, and again, I want to emphasize everyone here takes this very seriously, everyone's working very hard. What I did regret about the first ZBA meeting at which I wasn't given a chance to speak is that there wasn't really consideration of these criteria of significance, because this is what all this turns on. There's a process issue which we pretty much put aside. So right now we're discussing the question of the criteria of historical significance and the way that they were applied by the commission, the evidence that was heard. I think it would have been helpful, I won't belabor this, had you actually spent some time talking about the criteria and what they mean and how, rather than sort of assuming you know what they mean, asking the commission how they should be interpreted. I think that's part of the problem here. There's been kind of a disconnect between what the law says, what the commission understands these things to mean, and what the general public means. I had good reasons in my troubling comments a few weeks ago to talk about the subjectivity of the laws. Basically, these principles come out of standard national law. They're all over the place. There are 3 basic things. They have to do with the direct association of a person or a group on a place involved with history, local, state, or national, or so forth. The second place, we get these architectural, historical, physical characteristics. And then finally, something having to do with the possibility of providing evidence that's useful for interpretation, archaeological, architectural, or other physical evidence. So basically, almost all of our local preservation laws and national ones derive from these federal standards. The Amherst one is a little more expansive, and I quite agree. In some ways, it's problematic to interpret, not because it's a bad one, but because it tries, I think, as Ms. Wilder, as Ms. Stacy said, to be encompassing, to provide lots of opportunity for reflection and to be inclusive rather than exclusive. I think the only danger there, so the danger, I think, is not that things are often found not to be significant. If anything, they tend to incline us to be more willing to find things significant. and there's a certain amount of maybe overlap or ambiguity between certain points. So I think that's part of the problem. As far as the larger question of subjectivity, though, I think what we should say, I would like people to bear in mind, is that, again, talk of bad faith and ignoring evidence is unfortunate. I understand why people on both sides are frustrated with the behavior of the other. I think part of what it comes down to, though, is how we read evidence. I think there's a danger of assuming that things are too simple, that the law means one thing and that evidence means only one thing, and if you put 2 and 2 together, you always get 4. It doesn't work out that way. You know, everything we do is subjective. If you're a judge rendering a verdict in a criminal case, that's subjective. When you sit here and consider special permits or site plan approval, that's subjective. If it were totally objective and rational, infallible, and having only one possible outcome, we'd have computers do it. You'd put the evidence in, you get the verdict out. So that's, when we talk about the subjectivity, I think that's what we're trying to say. And I think my reading of what the commission did, and again, I was the chair of the commission, I served in the commission for 9 years, I teach a course in historic preservation, I know this stuff. My sense of what happened, just looking at it from the outside, but with some familiarity with the field, is not that the commission was wrong in the first place and was given evidence and refused to hear it. I think there's a 2-step process there. Again, you can agree or disagree with the outcome. That's the subjective part, though I think all these outcomes would fall within the range of the acceptable. But my sense is what the commission did in that second round was not just to look at the additional evidence, which I think was not materially different, though it elaborated on the case that the appellants have made, but they looked also much more closely at the law, that is, at what our zoning demolition bylaw 13 says. You know, they parsed those words. What does it mean to have an influence? Is it to be important, to be extremely important, and so forth? And they also looked at federal and state policy, the Department of the Interior standards, Mass Historical Commission, and so forth. And then above all, I think they focus on that question of the significance of the person in relation to the barn as such. So again, I would simply want to make a plea for a kind of tolerant interpretation here. I think the way the commission acted, even if not everyone agrees, obviously, falls clearly within the scope of responsible judgment. I'd just like to emphasize that I think, again, it's very difficult for an outsider sometimes to think about these things and understand why one comes to a certain conclusion that seems so obviously wrong from a different point of view. And finally, since I've taken up enough of your time, I think there is no one, with the possible exception of the property owner and his legal representative and that particular circle, who was pleased at the outcome that the barn came down. And I think the real tragedy, of course, is that we're trying to capture something that a preservation bylaw doesn't really grasp. That's the problem. And there are different solutions. There are much more rigorous preservation measures. I think there are some others I've been thinking about that might actually fall somewhere in between the demolition bylaw and a local historic district, which is fairly rigorous and involves a cumbersome process. But the whole process has gotten me thinking, and I would like to try to think of ways the town could work together, the planning board, the historical commission, and so forth, to find ways that would capture the issue of overall neighborhood character and quality of life, so that not everything has to rise to the level of extreme historical significance before we can act. And there are ways in other cities that this is done that also involves local participation. For example, giving a certain standing to residents so they have a voice in the process all along the way. But that takes us too far afield. But I thank you for listening.
Thank you very much. Yes, sir.
Hi, I'm Rolf Karlstrom, Precinct 10. I actually wasn't going to speak until Mr. Wald spoke again, and the reason I got up is that this plea for the nature of subjectivity and how we have to just put up with subjectivity, I think is very dangerous in this kind of a board. And I'm going to argue very strongly that while of course subjectivity happens in all of our decisions, that what we have to do is strive toward an evidence-based discussion and an evidence-based decision, and that subjectivity is something that we deal with, but it's not something that we go into our decisions trying to make the biggest part of that decision. So, as was made abundantly clear today and at the Historic Committee commission meeting, this is a volunteer group, and we're all volunteers. And that does not excuse people from making conscientious and evidence-based decisions. And I think that after extensive and very well-researched public input, in fact, the Historic Commission failed to address the evidence. And I wasn't going to use the word arbitrary and capricious, but that actually, after coming today, seems to be the best term for it. Their decisions did indeed seem to be incredibly arbitrary. They did not weigh the evidence that Mr. Brown was a historic figure. Ms. Stacy did extensive research, which I think the Historic Commission could well have done, and presented a very convincing case for the historic importance of Mr. Brown. In that discussion, read those minutes, there is almost no discussion of substance about the evidence of Mr. Brown's historic significance. These comments about everybody writes, and these are not impressive evidence-based rationales for making a decision. So it's a very difficult thing to be saying, but in fact, in this case, I think it's very clear that there was an arbitrary decision. And the question is, why did this commission not err on the side of preserving this barn? It's a strange situation to me. And to have Mr. Wald, both in this meeting and the meeting before, appeal to the subjective nature of all these decisions, and that someone's not going to like the outcome, of course, that's fine. I don't mind having an outcome, a disagreement on outcome, but to have a process where the evidence is not weighed and not discussed and a clear rationale is not given for a decision, I think is not acceptable. It does not give us good faith in the process at all. And I think Mr. Henke actually showed this quite eloquently at the beginning of this very meeting, when his logic was not consistent, and in fact he said the opposite of what the finding of the commission was, and it was Mr. Airgood who led him to the correct answer about the link between the barn and Mr. Brown. So there's an arbitrariness here. There's a lack of logical consistency that I think is troubling, and I think draws some question to the process. So it is a procedural issue. This particular barn is not the main concern here for me. This particular barn is gone. I think the process has been deeply flawed from the beginning. And I think the chance for the citizenry to try to correct a mistake, maybe it was, which it seems to be the board who has admitted, is really important here. And that no board is flawless. I'm not asking for every board to have the best rational decision in the world, but I think if there is a case where we've identified an arbitrary and capricious decision, and you can look at those minutes, and I do not see any evidence-based decision in those minutes, then we have to find a way to fix that, both on the global scale and the short-term scale. So the catch-22 nature of this appeal process has been beat to death. That, I hope, will be fixed by you or somebody soon. But the more immediate flaw in the process is that the Historic Commission failed to listen to your charge when you sent back to the remand. You asked them to ask specific questions and get specific answers. They failed to provide those answers for you. They revisited the question. They provided a debate that did not address any of the new evidence or your questions and came back with the same finding. So the worry here is that in this particular case, a person who has shown disregard for Amherst bylaws was given the right to tear down a barn. He did it, and that's the end of the story if this appeal is not upheld. That does not give citizenry much faith that the board in the next situation will recognize the importance of a structure and be willing to stand up and do due diligence as mandated by Massachusetts law to have a historic commission that will actually do a job in a conscientious way, and I don't say not conscientious, but an evidence-based, as much as possible, make a rational, justifiable decision for the historic nature of a building. So I think we need to move forward to have some faith in the citizens. We need to fix both of those aspects in this particular case. Thanks.
Thank you very much. Okay, any other public comment? Typically, we would offer the opposing party, as it were, the chance to make any rebuttal. I don't know, Mr. McConnell, if you wish to make any further comments this time.
Very briefly, once again, I think that is a mischaracterization of what the Historical Commission did. They met for 3 nights, discussed it, they heard all the evidence. They did not come out with a decision that some liked, but to say that they did not follow your charge, as I read your charge, you asked them to elicit new information. They listened to it. They did not agree that they should change their decision based on that. And I would just urge you to find that the Commission was not arbitrary, capricious, and unsupported by the law, because I don't think there's been any evidence whatsoever that they were arbitrary or capricious. Thank you.
Thank you. Before we close the evidentiary portion of the hearing, I did want to give Mr. Moore an opportunity to speak. We haven't called on him yet. Do you have anything to add?
I have nothing to add unless there's any question.
Are there any questions for the building commissioner? So there's a motion to, yes?
I would like
So perhaps
Yes.
I'd like to just say this before the hearing gets closed. It's with regard to the options available to this board for remedying the larger problem. There appears to be a larger problem here with the procedures, and I just want to get a little bit of that discussed while the public hearing's still open. And there may be other people who can speak to this more articulately, but the problem is that the demolition delay portion of our bylaw is within the zoning bylaw. So one of the solutions to this, which is outside of the purview of the Zoning Board of Appeals, is to take the demolition delay section and move it to the general bylaw. So it would take it physically out of the zoning bylaw and put it into the general bylaw. And what that would do, it would separate these processes and the powers in the appeals process. So I know that there's been a lot of concern expressed about the problem. It's been highlighted by this case. Anecdotally, I will say that from my own experience, not just in Amherst, but with bylaws like this, it often takes some kind of catalyst event to really cause change to happen. So without regard to what the zoning board does this evening, the larger question is how to remedy this problem. It's certainly worth having the discussion with this board, but it falls outside of the zoning board's jurisdiction. So ultimately, this would be a process to be considered through town meeting, which would remove the demolition delay process out of the zoning bylaw and put it into the general bylaw. So I don't know if Attorney Bard has anything else to offer on that as far as a large global view on the issue that's become apparent due to this case, but that's regardless of what the zoning board will do in this case. But I think it's worth mentioning while the public hearing is still open that this is largely a process that's outside of the zoning board's control. That is to fix the apparent issues that we're seeing come up now.
Your point is well taken, Mr. Bagg, and I didn't mean to prematurely cut off discussion of that specific issue. I believe that is important, so if we should do that now, let's do that. Ms. Greenbaum.
Yeah, I was going to save this for the public meeting, but I did write a statement after having read through all of the material that was in the envelope that we got last week. And basically, this has been a flawed process. The testimony of the applicant to the Historical Commission is full of subterfuge and persiflage on the Either he was out of the country or he was not. Either he knew about the pending appeal or he didn't. None of this, among other conflicting statements, is clear to me. There is no moral or ethical justification for tearing down this structure in such a hurry. There was testimony that the barn was in excellent condition, that it was not in danger of falling, nor a dangerous nuisance. A neighbor had offered to move it to his nearby farm, and the owner verified that he had no immediate plans for use of the reclaimed land other than improved landscaping and gardens. The processes in Section 13 relating to demolition delay are in direct conflict with the rest of the zoning bylaw, yet it is part of this bylaw. Chapter 10.1 incorporates a 20-day appeal period for any decision or enforcement action from any administrative office, including an officer or board of the town aggrieved by an order or decision of the building inspector, once a decision has been filed with the town clerk. But in this case, the decision was filed on September 17th with the building inspector, who can then issue a legal demolition permit without an appeal period, or in this case, once the structure has already been demolished. That is, unlike a building permit, demolition permits result in a permanent loss, not a delay. There is no process for appealing a decision of the Historical Commission, whose only power seems to be to advise the building commissioner. What good is it to appeal a fait accompli? Certainly, a cease and desist order can be issued for any other activity in conflict with this bylaw, but what good is that here? The only remedy would have been for the demolition permit not be issued until an appeal via Chapter 10.1 had taken place. And I believe that such due process, a close reading of Chapter 10.1 allows. In other words, I read 10.1, and I believe that had the abutters received the letter that was sent out on September 17th to Mr. Mora and was copied to several other boards, which is in there, but not copied to the abutters, that I believe that the appeal process under Chapter 10 would have allowed them to appeal had they gotten that notice. And there was certainly 2 months in there, almost 2 months, 8 weeks anyway, between that decision and the actual demolition. So that, since it's part of the bylaw, I really think there's a way of reading, and I think that's our job, to try to make a flawed document work, and then I think we could have made it work, but they were never notified, so that was another problem.
Mr. Airgood?
I am pretty narrow-minded about this. I think that we as the zoning board have almost nothing to say about this. I mean, our job here is we're just hearing an appeal. There are problems, whatever problems there are not the zoning board's problems. They're problems to be fixed in the bylaw. It's just irrelevant to us. We have to decide, we send it back and we have to decide whether to agree or deny the appeal. That's all we can do.
Mr. Chairman, if I can jump in, I agree 100%, but I think it's very important, particularly since several of the people who spoke said they're town meeting members, just to second what Jeff Baggs said, but I think you can close the public hearing and we can address it later because some of the folks may leave. The solution to all of these procedural problems is, as Jeff said, and I may have said it at an earlier session of the public hearing, is to take it out of the zoning bylaw, put it in the general bylaw, and just so you know, at that point, there's an immediate appeal that occurs that is an appeal to go to court, so you're not involved in this appeal to the Zoning Board of Appeals. So as I think a couple of folks have said, certainly, if nothing else, everybody agrees that the appellate process here was cumbersome and difficult for all of us. And unfortunately, this annual town meeting is very full with other bylaw items, but the hope would be that there'll be interest to get this on the fall town meeting, which would involve an amendment of the zoning bylaws, Jeff said, to take it out, and an amendment of the town's general bylaws to put it in there, in a nutshell. But I agree with Mr. Ergo that it's really not part of your decision tonight, but I just thought it was important for everyone who's still here to hear that anyway, and those of you who are town meeting members can vote in favor of same when it shows up on the warrant.
Thank you, Mr. Bard. I had a thought about this, and the thought simply is that normally there's a requirement to exhaust administrative remedies, which should be the appeal to this board. But it seems to me in a case like this, where the harm, basically there's no stay in place during appeal, so the harm could happen, that requirement to exhaust administrative remedies could be waived, which potentially would enable an aggrieved person to go straight to court and seek an injunction. And maybe that would have been a possible route in this case. And I don't know that it would be, but the thought occurred to me that maybe that would be a way until the bylaw gets fixed for aggrieved persons to, have a chance to have their day in court, as it were, before the demolition occurs.
But they still have to be informed of the decision, so that there is some time before the permit is effected.
I mean, I guess that's it's an important issue, and I guess
That's
it's
the big
related to the,
issue.
to the appeal. If
That
there's
it can't
nothing,
torn down the next day.
if there's, is there any objection at this point to closing the evidentiary portion of the
I was
hearing?
making that motion before.
Okay, okay. So it's so moved. Second, all in favor. Okay, so at this point, the board is not taking any additional evidence. You're welcome to stay. We will deliberate on what's been presented to us. I'm not sure how much longer we will remain in this hearing this evening. Again, you're welcome to stay, and although it's not appropriate for anyone to comment in the room, if you are here, if there's a question that comes up, we may ask it of you. So I guess the first item of business, I'm aware of the time, and I'm willing to keep going, but it's, I guess, a question of how late we want to keep meeting. So, okay, well, let's see what we can get done. So I think we've talked about this issue of the appeals process. I've studied the bylaw myself pretty carefully, looking at this, and I can't see a way around it. And I don't. It sounds like they're really short of changing the language of the bylaw or moving the demolition permit provisions to the general bylaw. Short of that, there's no easy solution to this. So I think, and we've covered the notice issues, the open meeting issue, and so I guess there's really just left for us to discuss the substance. Do we believe that the Historical Commission abused its discretion or relied on incorrect law in making its decision? Maybe I'll ask the town council to re-articulate the standard of review, so we have that in mind as we talk about this.
Fumbling my notes, but essentially the standard is I guess the inquiry was the board wrong? I guess I should say the Historical Commission, first of all, wrong as a matter of law. Did they create, or there legal errors in their decision? And more likely the area that you would explore is whether or not they were arbitrary and capricious in rendering their decision. Were they clearly erroneous? I mean, the case law uses various phrases like that, but the point of those phrases, such as clearly erroneous and arbitrary and capricious, is to underline the fact that a board like that making a decision is entitled to great deference, just as when your decisions get appealed, the courts are required to give you great deference. So the standard for the zoning board now is, in reviewing the Historical Commission, the standard is not whether you as a historical commissioner would have reached a different decision. The question is whether or not the Historical Commission's decisions were clearly wrong and unsupportable. In other words, not if it's debatable, as the case law says, if it's debatable, then you have to agree with their outcome. So the question is, were they clearly wrong? Was there no rational basis for them to have reached the conclusions that they reached? So that's why at the outset I, in shorthand, said it's a deferential standard, because your board, again, just as a court would, is required to defer to their decision unless it's clearly wrong.
Thank you. Mr. Ehrgard?
So I'd like to clarify the basis for what we will be evaluating in making that determination. So we have the decision in on remand. Let's see, is it dated? No, but Amherst Historical Commission decision on remand that has, it summarizes the public hearing, some testimony, and then there are There are findings with the review of criteria that start on page 8, and decisions then are reflected in the vote table on pages 11 and 12. So the question I have is this, we of course have heard various facts. We heard more facts. We have facts on the records. We heard facts on December 20th. We've heard testimony today. Do we look at these findings and the vote and make our decision focusing on those? Or as we go through these, do we pull in other information from the record? So please explain, please help us with that.
Well, all of the above. In other words, you held your own public hearings earlier, although granted it was truncated, but you heard some information directly. You have the minutes of the Historical Commission's proceedings, and then the decision, of course, is to some extent sort of a summary, a summation of what was in the minutes, or at least not necessarily of what was in the minutes, although some of it is, but then also, more importantly, the board's findings. And so you look at all of the above and then evaluate specifically. You have the board's decision in two formats. It's summarized in the vote table, but the vote table just gives you the votes. And so it really is looking specifically, I guess, when after the summary of the testimony, beginning on page 8, findings, review of criteria. That's really what you're looking at.
Should we go through each of those criteria?
You could.
And I think we are making findings essentially on those findings in the decision on whether is it not clearly wrong and unsupported by evidence.
Right, and just when you use the word findings, so you're not making your own findings, but
Right.
you're gonna.
We're making a
you're-
determination on.
Exactly.
Right.
Right.
Okay.
Mr. Bagg?
So this is just a question for the board members and possibly Mr. Bard, but there was some testimony given to the fact that the Historical Commission didn't make reference to all the documents within the decision. So I'm wondering if perhaps Mr. Bard could just explain a little bit about the process of decision-making in general, whereas the Historical Commission was given all of the material and they had it before them and it was included in part of the record. So whether they were required to cite every document that they used, or if they could, through the course of deliberation, move some of the material out without actually saying that they didn't find factual information within that. And I guess the question goes to the zoning board, that they have the same information before them, and whether in their deliberation they have to make notation of every single thing that they've reviewed and discounted certain documents, or whether by making their final decision they're identifying which documents they've referred to, what they're using to make their decision. So I'm just wondering if you can give a little guidance to the zoning board as to how detailed the decision actually has to be in order for it to be usable in this kind of scenario.
Well, in my opinion, that's up to the zoning board. It need not be as detailed as the Historical Commission's was, or necessarily as detailed as a typical zoning board decision is, because you're not a fact finder here. I mean, normally the zoning board would make certain factual findings, I would hope, and then based on those factual findings would make a decision. So if the application before you has to do with a request to expand a non-conforming structure, you'd make certain factual findings as to the current lot, current building, and the proposed addition, and findings as to its impact on the neighborhood and so forth. Here, that level of factual inquiry and finding was the Historical Commission's job. So the zoning board's job here is not necessarily at that level of detail. If you choose to go that deep, you could, but in this instance, you're at an appellate level, and so you need not go to that level of detail. And to answer the other specific question, just as the zoning board might on original applications before the zoning board and as was true for the historical commission, no, there's not an obligation to refer to every document that had been submitted and make a specific determination as to whether that document was persuasive or not persuasive, or those facts persuasive or important or unimportant. Boards and courts look to those documents and facts that the board found particularly compelling, and you look at those, and if this board found other facts more compelling that the commission didn't take into account, then the zoning board can specifically reference those. But it's not necessary that either board review every single document and bit of testimony and sort through it.
And may we take as accurate the factual statements that are in this finding if we don't have, let's say that a statement that the barn is not listed on the National Register. I have no independent information about that. I don't know that anyone here does. Do we take as correct factual statements unless we know them to be incorrect?
Again, that's up to you. I think you can give the historical commission deference. You've heard of their qualifications. You may or may not be aware personally of the background, but you heard that one was a longtime commission member, has done that kind of work professionally and so forth. So it would be appropriate. I'm not saying you have to, but it certainly would be appropriate for the zoning board to look at the experience and qualifications of the historical commission members and say, gee, if they report here that it's not listed on the National Register of Historic Places, we can accept that as a fact. You don't have to, but it would be reasonable for this board to accept their finding to that effect. Yeah.
So,
Well, and for my part, and without meaning to jump ahead, but on the substance, and I have reviewed carefully the minutes of the Historical Commission hearings on remand and the materials that they reviewed, and as well as the provisions of Article 13. And under the standard review as articulated by Town Council, I just could not find that the Historical Commission acted arbitrarily or capriciously or in violation of the bylaw. I think that the way this entire process unfolded was unfortunate. I think that there was this unfortunate glitch in the appeals process, and perhaps a direct appeal to court may have succeeded where this process has not. But in the end, again, reviewing all the materials and all the testimony, I would not feel comfortable reversing the decision of the Historical Commission or of the Building Commissioner. And again, I don't want to rush the process, but I just wanted to let you know, I think I owe it to you to let you know where I stand on the substance of whether or not the barn was a significant structure. Even if we were to find that it was significant, there would be an additional finding required that its demolition would injure and the exact language, I guess, is that the demolition would be detrimental to the historical or architectural heritage or resources of the town. Again, I just think that based on all the evidence, that would be a finding that I would not be able to make. As you may know, to reverse a decision of the building commissioner requires unanimous vote of this board. And if, as I'm stating, I would be unwilling to vote for that outcome, the appeal will not succeed. But if my colleagues wish to articulate their view or talk me out of mine, I'm happy to hear it. But that's upon review of everything, that's where I stand.
well, I think that we need to, Mr. Bard, do we not can we make a general finding such as that, or do we? Or do we not need to make determinations relating to each of the criteria?
You need not. It's really up to the board how you want to approach it. I mean, I think the chairman went to some of the key points, and I think it would be useful in the decision to at least address the key findings that would have to be made, and in order to reverse, if you will, and then a finding by this board that you can't make those findings, if you will, of significance of the structure and the individuals and so forth.
So may I then, to me, this turns on 13.4102. At the December 20th hearing, I specifically said that the thing that was missing and that I thought needed to be addressed on remand is that there was no statement about the relationship between this identification association between the structure and a person of significance. And also I had questions about the whether the chalet style of the barn undermined its being deemed an historical structure, and that was clearly addressed by Mr. Hankey in his statement in here. But so let me take a minute on 13.4102. So please bear with me. So what does 13.4102 you need to find? You need to find that the structure is identified with a person of some influence on society. So by the way, I will find that in the findings that there's a basis for a negative conclusion on that, even though it's not really, it's stated directly by one person, by Meg Vickery, that it's not associated with that association between the barn and the person and a person of some historical significance doesn't exist. So is identified. This is identified is in the present tense. You know, is identified, what does identified mean? Identified in by dictionary definition is associated or affiliated. Associated means connected in the mind. So it's connected in the minds. Is it when? Now. Is identified. It's not was identified when a person of some historical significance lived, but is identified. Is identified who? With one person? It has to be identified with some group of people, with some number of people. The fact that this house was on the market for some period of time and is not identified as and associated with Warren Brown has some bearing on the fact that this connection of the structure to this person of some historic significance is rather minimal. You know, in the decision, and the decision. There's some things that are important. Linda said that she referred to Boltwoods, Dickinsons, Gaylords. You know, there's Seeleys, there's Frosts. There's people who really have some significance, and that significance survives their deaths. It goes into the, you know, it lives into the present. So Warren Brown was found to be a person of some significance, but you know, you can be of some little significance and some big significance. This is a man of pretty little significance. So in these writings here, what did he write? He wrote for the Amherst Record throughout the 40s. He declined an invitation in 1945 to write for the Springfield Union because he said, I haven't any ideas big or grand enough to write about. So he's a man of some significance, but the members of the Historical Commission in their finding on 13.4102 talk about, you know, they say he was a writer of some sort, but he's a developer, he's a businessman, that's what he was. So if he were a bigger, so what's the relevance of this? The relevance that there's a connection between this significance and this identification. Because he was has relatively small significance, this identification was really attenuated. So notwithstanding the original, I believe the more important evidence of what the commission decided is what's in writing and not the oral statement made by Mr. Hankey tonight. So I find that, you know, that this determination, that there was 5 to 0, it was 0 to 5 in the original. In the original, was no one thought there was this connection. In the remand determination, what was it? It was 0, 3, and 2. So it's a little bit of a close call, but I think, you know, I can't find that that's an arbitrary and capricious decision that, that this barn, you know, wasn't identified in the manner required by 13.4102 with Warren Brown, a person of significance. So those were the only issues that to me, those were the issues I would have remanded on only. So really, that's all I have to say now. And I am in agreement with the chair.
Ms. Greenbaum?
I don't believe in tearing down structures without going through the whole process of, even waiting a few weeks, you would have found out that Mr. Gillen would have moved the barn. And I do believe that if you read Section 1, appeals to the Board of Appeals by any persons aggrieved by reason of their inability to obtain a permit or action from any administrative office, et cetera, including a board of the town, aggrieved by an order or decision, can appeal. And I think they could have appealed after September 17th. Even though they were told that they couldn't, I think they could have. So that we could have gone through this process and Mr. Gillen would have had an opportunity to come forward. I was around in the 50s and 60s, and I knew these people. In my house, it is the Warren Brown house. In my house, it is the Warren Brown house, because we've been around this place for, oh, I counted the other day, for my husband. He's been here now 58 years. He knew Warren Brown. He knew Granby. I knew Robert Frost, too, through my home. But if you've been around this place for a while, unfortunately, there are not very many people left around here. Mr. McConnell was around here then. But not many else of us who knew Warren Brown or Jeffrey Brown or Robert Brown or any of the other ones attached to that house. And I think they should have been allowed to go through 10.1 as of September 17th, which was well before the building permit was given out, and found a way to save the barn. Given that it was controversial, I think that they could have leaned a little bit in that. I don't have any cavil with the process of the Historical Commission. They just are basically all newcomers to the town, and they don't know local history because they haven't been here, they haven't lived it. Unfortunately, I'm an old cow and I've lived it. But I think given that it was controversial, if some of the members had just leaned enough the other way, that we might have been able to move the barn to Mr. Gillen's property down the street. And so my problem is more with this appeal process and it not having been utilized. And I think it's because town staff didn't advise them that was their reading of this bylaw. And they didn't get legal counsel who might have agreed with me. But I'm torn because I don't fault the Historical Commission for what they did. They worked very hard, but they're basically newcomers to town.
I think on the issue of the appeal, and I'm looking specifically at section 10.1, the appeals provision requires a person aggrieved by inability to obtain a permit or enforcement action from an administration office under Chapter 48, or by any person aggrieved by an order or decision of the building commissioner. So we really needed, and town council will correct me if I misspeak. No, it's saying an appeal may be taken by any person aggrieved by an order or decision of the building commissioner. So the permit, that was the decision of the building commissioner. Again, Mr. Bard will correct me if I misspeak. But I don't think it's fair to fault staff in this matter. I think that there really was no standing to appeal until there was a building permit from which the appeal could be taken.
As you can appeal a decision of the Historical Commission under that section?
Well,
It's a
part,
far-fetched, but I mean, that's what we've got to here to deal with, this language.
it's part of the complications that arise with this being in the zoning bylaw, because in a general bylaw, the Historical Commission's decision to allow a demolition or deny a demolition would be immediately appealable by either the person who wanted to demolish or the neighbors who didn't want the demolition. Here, because it's in the zoning bylaw, it has to go to the building commissioner, who makes the appealable decision.
Well,
So-
is there a delay, if it were a town by law, is there enough delay in there that it's appealable before the building is knocked down?
Yes, I mean, when the decision is made, let's say, to allow the demolition, when that decision's filed, it can be appealed at that point to court.
But you can't here.
No, here you have to do what was done, which is, as I said, you have to go to the building commissioner. It's only when the building commissioner makes his decision that a right of appeal ripens.
And so as I was trying to suggest earlier, in situations like this, aggrieved persons conceivably could bring an action for an injunction claiming irreparable harm if the structure is demolished and proceed directly to court. But I
Now or not?
well, no, I think that could have happened. It didn't happen, but I think our hands are tied in terms of when we can take an appeal under the language of our bylaw in Chapter 40A. So I think staff acted appropriately in waiting for the building permit to issue before the appeal could be taken.
And our decision, according to the way it's stated on the agenda, our decision is yea or nay on the building commissioner's action. Not on ultimately it's the historical commission, but the motion is yea or nay on the building inspector.
I defer to Mr. Bard on that. It's one of the unfortunate complications of the posture of this case.
Well, I gotta find my paper, I had it a minute ago.
So,
Yeah.
don't we affirm the decision of the building commissioner based on
That's
our
what I'm
determination that the decision of the, on our, how would you put it? Do you put in the negative, that based on our embrace of the decision of the historical commission,
I mean, honestly, the building commissioner's decision here, I think the better course is to look past it and to go to the substantive decision of the commission, because the building commissioner was going on, he would have denied the demolition permit if the commission had imposed a delay and somebody came into his office, or in this case where no delay was imposed, he granted the demolition permit. So I think you look past the building commissioner's decision and you look at the historical commission decision.
so an appropriate motion is to deny the appeal from
The appeal in the DDA 2013?
-000.
Yeah, I mean, it's a good point. We could look back at the actual application on appeal, because perhaps it was appealing the building commissioner's grant of the permit. But in any event, I think you have to address the historical commission decision. But we should look at the application for how the final decision is framed.
Yeah, the appeal, I'm looking at the application form now. It's an appeal from the permit, the demolition permit issued on November 5th. But again, as I read the zoning bylaw, that's the only appeal that could have been taken.
Right.
So
So it's the only decision we can make.
it's, again, it's procedurally, it's unfortunate. Again, I would just I would note, as I did earlier, that one of the requests for relief in the initial appeal was to remand or return, rather, the matter to the Historical Commission for reconsideration. And that relief was granted. As I said earlier, I don't believe that the Historical Commission acted arbitrarily, capriciously, or applied the incorrect law. And so I would affirm the building commissioner. Is if
Based
so-
on our
so-
finding, wait a minute, we're going to affirm the building commissioner's order based on our finding that the historical commission's decision was not legally defective.
Yes.
Right.
So I move. Mr. Beal?
Yes.
This.
You know what, I just, and I'm sorry, I just wanted to take one last look and make sure we covered all the issues raised.
Sure, maybe this is helpful, maybe it won't be, but the way that I was hearing this discussion was that the board is dealing with ultimately the issuance of the demolition permit, but in order to issue that permit, the building commissioner relied on the decision of the historical commission, and upon Ms. Stacy's appeal, it was based on the fact that she was not notified, and also based on the fact that there was believed to be new information that had not been submitted. So I believe that the board has remanded this back to the historical commission, and those issues have been determined to not exist anymore. So looking at the original appeal, which Mr. Beal was doing, I think that the board can make multiple findings, as have already been done, such as the historical commission made the appropriate findings that support the zoning bylaw requirements, and also clarified and removed any issue of a butter notification, and also gave the,
Find that?
well, I don't know if you have to find that. I'm just trying to recap that through the remand, the petitioner was given the opportunity to present all the information to the historical commission. So those were some of the issues that were not resolved and brought in the appeal. So those are perceived to be resolved.
I had just a couple other things. Do you need to respond?
No, I don't need to, but I hope that it would be great if we could simplify and affirm the building commissioner's order as a result of our affirming the remand decision of the historical commission.
So you could do it one of two ways. One is you could, frankly, it would be good to get some of the substance in here that you recited about 5 minutes or so ago. So perhaps you start by affirming the decision of the historical commission, and based on that, and perhaps that's what you're just saying, affirm the decision of the building commissioner.
Well, before we get to that, there are 2 points I wanted to make quickly. One is that we did determine at the December 20 meeting that, and again, in consultation with town council, that the association does not have standing to appeal, so that because it was not in a butter. So the appeal was from Ms. Stacy. The second thing is, I was troubled about the process, and also about some of the inconsistencies in sort of statements. And I guess I'll direct this comment to you, Mr. McConnell, for Mr. Tseng. And I think that was unfortunate. I think there's a level of distrust that's here, and maybe partly based on some of those perceived inconsistencies. And I would just urge your client to work with the neighbors, and easily as a neighbor, this whole episode could have really been interpreted as an intentional poke in the eye, and I hope that wasn't the case. I really trust it wasn't, but it has at least the appearance that it could have been. And again, I'm not a mediator, but I would simply suggest that he try to work with the neighbors, and if he does develop the property in the future, that he try to bring some of the neighbors' concerns with that, and I think it'll make his life easier, if nothing else. So anyway, those are 2 points I wanted to make. So there's a motion. I think we've made sufficient findings, and so unless there's any disagreement on that point, I would entertain a motion.
Well, Mr. Bard has suggested that we should restate in our findings some of the facts that
Well, sure. I think we can find that the historical commission applied the correct provisions of the bylaw. That the evidence is that they considered Based on the minutes and the testimony, they considered all the evidence. They're entitled to weigh the evidence.
Supported their determinations.
They place the weight on the evidence that's appropriate, and others may disagree, but I don't think we can say that they've inappropriately placed weight on the evidence. They considered all the evidence. They made findings of fact, and they applied the correct law. And I would find they did not act arbitrarily or capriciously. So therefore they did not act in abuse of their discretion.
Mr. Chair.
Yes.
Question. What if we're a hung jury?
Ms. Greenbaum, can you speak up?
Oh, I'm asking the question, what if we are a hung jury? We don't have unanimous.
A reversal requires unanimous vote of the panel. If one member would vote to reverse the decision, that's insufficient. It would have to be 3 votes in favor of reversal. So those are the facts that I would propose that we find, or at least those of us who are willing to find them. And if we're ready, Ms. Greenbaum, I don't want to cut you off. If you have other facts that you would...
No, I don't. I have to think. I don't know what to do.
You know, may I ask, Mr. Bard, should we add, I would think it would be important to add that, should we add that principle among these facts, that we agree with the Historical Commission's findings that the structure, while of a certain age, is not kind of a historically important, historically and architecturally important and culturally important structure in the town, and that the owner, Warren Brown, is notwithstanding the fact that he, was a person of some significance, was a person of some limited significance, such that this structure was not identified with him in the manner that would have warranted issuing a demolition delay.
I think that's different. I think what we're being asked to do is
that's why I'm asking him whether we should add real facts.
I mean, it's up to you. You began that by saying you would find, so rather than have you make an independent finding, that the board finds that the Historical Commission's findings of all of the above was well within its discretion.
But we're just asserting it.
Yes, but in other words, you're not making an independent factual finding.
We're not saying why we find it. We're just asserting. We're just stating it.
Yes, you evaluated.
Okay, well, I evaluated, and those are my conclusions.
Exactly.
And that's legally appropriate.
Yeah, so it's up to the board if you want to include it. But I mean, it's a central element in the Historical Commission's decision. So if the board wants to include that, the zoning board wants to include it in its decision, that would certainly be appropriate. It's up to the board.
Okay, well, if you want to put your statement of the facts you'd find on the record, I guess this is the time, because otherwise I'm going to call for a vote in a few minutes.
Just that I think that given it was controversial, I think they should have found a way to be a little bit more lenient.
That's not irrelevant. That's not relevant.
But
So I would.
But I'm a preservationist. I don't tear things down. I've got Wall of Twine. I think I started 50 years ago. I don't know. I've got everything. I don't like to get rid of things.
Well, I don't know if it's possible to say at least one member of the board, found, based his decision on what he considered those fundamental facts that he found to be, consistent with and incorporated into the findings of the Historical Commission.
If I can interject a little editorial comment.
Yeah, help
I spent about an hour today finishing up a supplemental brief to the Land Court, backfilling for one of the decisions of this board that has been challenged in Land Court, in which the board had a hard time coming to a consensus. So it would be nice. In fact, what I had to write today was that a 2-to-1 vote to grant a certain permit was a denial. This had to do with a restaurant application that was before you a few months ago, where everybody was coming from a slightly different direction. So to the extent that even 2 of you could agree on some language, that would be great.
Well, I would join I would join the findings of fact as proposed by Mr. Aragon, and for the reasons I stated earlier. So I understand that boards often may come to agree on an outcome, but not agree necessarily on the reasoning. But I think in this case, I think it's fair to say that we're of one mind on that.
And in this case, the outcome is clear, so it's different from what I was alluding to, but
Yes.
it did conjure it up since I was working on it just a few hours earlier today.
Well, we
Well,
don't
then
always agree,
alter
but
that.
tonight we do. So do you want to make a motion?
No, you do it.
I move that we affirm the decision of the building commissioner, which in turn, in which we affirm the decision of the historical commission, and that we find it was not arbitrary, capricious, or rendered an abuse of their discretion.
Just covered it, yeah.
So maybe that motion then would be preceded by some of the findings. Jeff will write it up, but some of the findings that Mr. Ergood was articulating, preceding the motion, that sort of thing.
That would be the idea, I
In
think.
fact, it's true.
Sorry?
In fact, it's true.
Yeah.
Those findings did
Well,
precede the motion.
it goes without saying that our decision is based on
Yes.
our evaluation of the historical commission's decision.
Right. But
So-
in terms of how it gets written up, Mr. Bagg will write up the findings and then get to that conclusory motion, if you will, based on those findings.
Is there a second?
Second.
All in favor? All against? Abstaining? Anything further?
Got that. Sorry, yes, thank you.
I abstain.
All right. Thank you, everyone.